The extension of interim order, please.
My lord, may I make
Restoration, my lord, may it be allowed.
Not right now, not right now, not right now.
Has been long back. It has been dismissed, and along with the interim order, my lord, I'm
Not our fault, it was dismissed.
understand.
my lord, may I make board Brahmin may make a prayer, my lord?
You are coward, Brahmin.
My
Yes.
lord,
Mr. Bhattacharya, we
my-
appreciate your seniority, but
only
we cannot
one-
make an exception for you.
only one second. My
No, you get your time. Yes.
daughter, my daughter was taken after the death of my wife in 2016 by her mother-in-law, by her
Grandmother.
grandmother. Since then, I have no touch with my daughter. I have filed custody application that was rejected with the visitation right. I tried to have avail the visitation right, that was not allowed. Then, my lord, I filed an application. I mentioned the matter before your lordship for hearing.
So,
Your
Bhattacharya will
lordship
take
said
care of this. We are
that he
trying our
filed an
level best
application
according to our capacity. We cannot do more than
only for orders that your lordship can enforce the visitation right. No hearing.
So, Bhattacharya, please wait for some time.
Enforce the visitation right.
We cannot give the we cannot give precedence.
I am
to
not
you.
hearing. I will not make a prayer
No,
for
no,
hearing.
there will be an argument, obviously.
No, there will be no argument. Only
How can I-
visitation right. Only
So,
visitation
Bhattacharya,
right.
we are not, we cannot make an exception for you. If you do that, that will be, I mean, injustice to the people who are
Only
senior to you.
visitation right, my lord.
Mr. Bhattacharya, we cannot make an exception. With deepest respect to you.
The next week I will try.
Next week you try because we will not be. I will not be there. I will be in Andaman. Please try in the next week. Please try in the next 2 weeks so that
Sure.
as an urgent matter this can be taken up. After coming back, we have full determination. So we'll.
Poor
what-
Brahmin without money, nothing else.
No, sir. No, you have heard us. Non-prosecution handover is.
Earlier occasion, this contempt application was allowed by my lord. It is not.
We'll look into it when you take it up. Not now. Yes.
Your lordship, may I
MAT 1594 of 2025 is allowed on contest, thereby setting aside the impugned judgment dated September 11, 2024, passed in the writ petition, as well as quashing the order dated June 2nd, 2025, passed by the respondent number 5. Any action, steps, if taken pursuant to the impugned judgment of the writ court or the impugned decision dated June 2, 2025, are hereby quashed and stand reversed. It is hereby declared that the railway authorities have no manner of right, title, or interest in respect of the subject plot, being CS and RS Dag number 2246, corresponding to the MOSA we have given.
Yes.
In the event the subject plot stands recorded in the name of the railway authorities, the corresponding entries in the records of rights shall be rectified by the appropriate authorities, and the name of the appellant shall be recorded in respect of the said plot upon being approached by the appellant for such rectification. Can 2 of 2025 is accordingly disposed of, no arrest to cause admission. What engine?
Item number 2 is for correction, my lord. Your lordship. The date of the order has been gone down as 2025. It will be
Oh.
2020.
In the judgment dated March 25, 2026, the date of the judgment was erroneously recorded as March 25, 2025. Let the said date be deemed to stand corrected and read as March 25, 2026. Thank you. Thank you and sorry. Yes. Next.
Item number 3.
Item number 3, man, appearing for the appellant.
Want to
This
withdraw the appeal?
this is pecuniary jurisdiction. It ought to have been before the district. 1,30,000. I flag mark the plaint, lordship.
Thank you.
And vocalatnama has been filed by us. No objection. Okay. I have received no objection in this brief. After that, I have instructed.
So difficult. Learned counsel appearing for the appellant submits that the appeal has erroneously been filed before this court, although it is the concerned district court which has pecuniary jurisdiction to entertain the appeal. Accordingly, on the prayer of the appellant, FAT 29 of 2026, along with CAN 1 of 2026, are dismissed as withdrawn with liberty to the appellant to prefer an appeal against the self-same impugned order impugned judgment and decree before the appropriate court having jurisdiction, pecuniary jurisdiction.
Well, I also found it that well, there was no certified copy. Leave was granted to file without
You
certificate.
have not filed it.
No,
So there is no question.
well,
of making.
I saw it from the record, madam.
For the respondent.
What is the
So, for
correction?
respondent number 5, this
Question?
is mentioned that on my instance,
What is the
you have
correction, please?
indicated the correction. It's a small typographical error with regard to the order date in para 9.
Only this?
Only this.
You have also checked. In the judgment dated March 31, 2026, comma, in the fifth line of paragraph number 9 thereof, comma, the date was recorded as March 15, 2023, whereas it should be read as July 24, comma, 2024. First up, let such correction be deemed to stand incorporated in the judgment dated March 31, 2026. We'll keep this also for the records, yes.
Number 5, my lord.
Yes, Mr. Sahu.
Matter was adjourned. My lord, fine, I could not preserve the fine, number 1. I have checked it up. One Soilajananda Bhattacharya for the appeared on behalf of the respondent. He has also died. I have checked it up. Well, it will be better to serve the administrative notice. It will be better.
Mr. Sahu, comma, learned as advocate appearing for the appellant submits that no papers regarding the appeal could be traced out by him. Pusap, it is also submitted that the erstwhile learned advocate who was appearing for the respondent has since expired. Pusap, accordingly, comma, it is rightly pointed out by Mr. Sahu that for the ends of justice, administrative notice be issued to the parties. Pusap, we accept such contention. Pusap, accordingly, let administrative notice be issued to the parties indicating that the matter shall next be listed in the monthly list of June 2026. First up, a report regarding such service of such administrative notice shall be furnished by the office in the meantime.
I have checked it up. Matter relating to section 24 of the Hindu marriage.
Oh,
I do not
Mr.
know.
Sahu, please ask your clerk to check up whether
Yes,
you
yes,
have to put in
madam,
those.
this week I will check.
After line add করে দিন যে the appellant shall take appropriate steps in that regard.
Actually, it is a brief of my senior when I was in.
It's a legacy you are carrying.
Number 6.
First time was checked. None appears for the parties at the time of call. As a last chance to the appellant to argue the matter, comma, the same is adjourned till May 5, 2026. 5th May এগুলো সবার। Same.
Item number 8.
Same.
Item number 9.
Same.
Item number 10.
Same.
Item number 11.
Same order.
Item number 12.
Same order.
Item number 13.
Same order.
Item number 4.
Same.
Item number 15.
Yes, Mr.
Let me the appellant before your lordship. The suit for partition only initially an administrative order of injunction was granted. Subsequently, same was vacated under Order 13 Rule 4 on the ground of suppression. If your lordship takes up the
You are challenging the 39-4 order.
yes, was it
Suit for?
suit for partition. Now, if your lordship takes up the order,
Yes.
memo of appeal, my lord, if your lordship may kindly
Right.
consider. I
What is the date of the order? This printed one.
Yes,
Order
the
number
date of
5?
the vacating order is, my lord, dated 15/5/2024.
15/5/2024. Yes, yes.
And previous to that, my lord, I am drawing lord's attention.
First order.
First order 20th March 2024.
Let us see the first order first.
Your lordship can considered and after going to the petition submission of learned counsel such and such.
Yes.
So
Let
this,
us now see the implement. Yes.
now if your lordship can takes up the order passed on 15th May 2024.
Longish order.
Yes. I'm drawing lots of attention. So for the internal page 2, the contention of the defendant, that form first paragraph, defendant further denies, my lord.
Yes.
Further denies that Bibi Salema Khatun, married son of Monsuddin and defendant number 3 party were born out of their wedlock, and that the husband of Bibi Salma married second time, and out of this wedlock, defendant number 2 party was born. That after Bibi Sakina died, leaving behind the plaintiff and the defendant number 3 as the legal heirs with half share each in the suit plots. So this was the defendant's denial. Now, if your lordship can turn to, kindly come to last but third paragraph, Bibi Aris Asiran, my lord will find. Wife of Mursuddin had her own share of such and such in the arrest, and later the death of Mursuddin inherited such and such and sold these lands by registered deed dated such as to the Kaminuddin Sheikh Sabtaru, and they put them in possession. Niyazuddin son of Mursuddin, my lord, these are the facts which have been stated. How the defendant is claiming title over the property. The main thing I want to draw illustration, internal page 3, third paragraph. Defendant number first party admits that their ancestors sold the lion's share to other purchasers, but the plaintiffs with malified intention did not disclose the names.
The defendants, yes, yes.
This is the first suppression. The defendant first party admits that their ancestors sold the lion's share to other purchasers, but the plaintiffs with malified intention did not disclose their names.
So boils down to non-joinder of this person.
At best, non-joinder. Now, my lord, can I turn to the plaintiff states? In my written objection, my lord, can you consider that the defendant took the plea. Last but fourth.
Yes, got it.
That R.S. Khotian and another co-tenants. But as per R.S. Khotian, the plot was originally owned by Mursuddin, and during KB stage, such and such was recorded in favor of Mursuddin in green ink. And thereafter, erroneously, the record was 50% in the names of Mursuddin and Arsena Bibi in red ink, which has no basis and requires to be determined in court. My lord, this green ink and red ink has some significance. My lord, can you recall that the workshop which he all attended, my lord? The green ink is for the purpose of what is the rectification required, and red ink is for the existing which required to be adjudicated. So it is not merely, my lord, the red ink and green ink has that Mursuddin sold entire suit property to ancestor of this defendant by deed number such and such. As the record of rights cannot be treated as document of title, subsequent recording in R.S. Khotian in red inks liable to be ignored. As such, suit is not suffering from defect of parties or non-joinder of the other plots. There is no suppression of facts, plenty prima facie case, plenty is entitled to get injunction. Now, my lord, because it is a Mohammedan law, a single plot can be also sought for partition. That all the now the findings of the learned court below, if your lordship can turn to internal page 5. After going through the petition, my lord will find that is a portion objection submission of the learned counsel. Petition to petition together, 39(4) and 1 and 2. The defense counsel filed petition to treat petition 39(1) and 2 as written objection to 39(4). The petition 39(4) fundamentally deals two aspects: whether there was suppression of facts or whether new circumstances have arisen. In the present case, the plaintiff counsel has per record was on the back foot on two accounts. The documents referred to during the hearing, being the deed of 1959 and other documents, were not placed before the court. Neither was it served with the defendant number 1 party, who could have perused the same during submission. The second aspect is no petition was filed to state their amendments and contention of this plain taken into account, which resulted in defendant number 1 party conflicting themselves only to injunction, confining himself only to injunction petition, wherein there is no mention as Asiran Bibi, the arrest record owners, neither the other co-owners as mentioned in para 16 of the plaint. The result being that the bulk of the submission defendant number party in prejudice was based on non-joinder of the parties and suppression of facts. My lord, apropos to this, my lord, I takes up my application, my lord. It is said the Asiran Bibi's name was not been disclosed. Your lordship, it takes up page 18. My lord, got it?
Hmm.
Last 1, 2, 3, 4, 5, 6, 7 lines from the bottom.
Yes, it's underlined.
Asir will be
Underlined. Yeah. Yes.
now I'll carry this next page, page 19. The family chart has been given where I have disclosed what the years. Our case is that Masuddin was the original owner. He transferred the property in the 1957. After that, we being the defendant number 3 and the plaintiff became the half share of the. This was our specific case. Their case is that no, Arisar has 50% share from them.
Ashiran claims to your vendor.
Yes, I
his
know.
wife.
Maisuddin transferred to Salma, intershare. According to us, Maisuddin was the original owner of the intersuit property. Intersuit property transferred to Salma. From Salma to
You.
I and defendant number 3
And they are claiming.
is to Asirans.
Ashiran is claiming through Isuddin.
Yes, Maisud not claiming. He's claiming to be the 50% owner. My lord, here, my lord, neither the predecessor of the
You're not claiming through anybody.
No, not anybody. Because that is why, my lord,
They produced title deeds with their 39-4.
no. So far, our title did we have produced.
That also it says that 1959 deed was not produced.
Approval to this, my lord, can I turn to my application itself? The order sheet, my lord, not the application, order sheet itself.
The first order you said that the Xerox copies of documents are.
Yes, received original documents. My lord, got it at the
Which order?
dated 20th March 2024.
Yes.
At the left hand side, my lord will find received original documents. It was produced. After that, original documents are taken. Now, my lord, can you turn to order number 2nd May 2024. Defendants file some documents with PTC. Plaintiff files a petition for giving liberty to file the documents. Copy served. After that, my lord, this is the order, and this order was passed. We already tendered those documents. It was there.
This petition for giving liberty to file document are the original documents.
Yes.
Of which you filed Xerox copies and sought liberty.
Liberty. That is why, when the previous order, my lord will find that I take back the original one and I sought for to file in the same. Now, my lord, can you turn to?
So, deed of 1959 was also there in those copies.
Yes. The photocopy was there because from the order dated.
No, it does not refer to any particular document. So, that's what it is.
No, here your lordship will find.
Anyway, let us continue.
Yes, ma'am.
Page 5. Be that as it may.
Be as it may. We came to the merits of the suit. The plaintiff filed the RS Khatian pertaining to the suit. The RS reveals the share of Kamiruddin Sabratu, wherein the injunction petition plaintiff has malafidely stated, para number 11, that defendant number 1 and 2 have no right title interest and the suit property. The RS was filed by letter by the plaintiff's own document. His contention of para number 11 of the injunction petition is contradicted. The plaintiff version is hit by principle of appropriate and reprobate, which applies in a situation when a person has to choose between two rights, stance or position. After assessing or acknowledging the one right, stand position, the person in question cannot later choose the other one to gain benefit from both. Therefore, the plaintiff has filed the document to show RS recorded tenants, and on the other hand, stated the defendant number 1 and 2 party have been made party to the suit to alloy in a partition suit, stating that there is no share, stating that no share. From the plaintiff's own documents, it reveals the Muslim share is stated to be 16 annas, by which he transferred the total share required to be proved by trail and evidence in court. This is the finding. Delhi High Court judgment, skipping over the same. Next page. On 3rd May 2024, Malat got it. Next page.
Yes, but it says that the 20th of March, the ad interim matter was moved with document list under Order 13 with only plot information. So it records that no other document was filed.
Yes.
And 8th of April till then, no document submitted or supplied.
3rd May, petitioner was filed to put up case records to file documents. Copies of in prosecution gathered that filing of documents could have been momentary lapse attributed to human.
It records that on the first day, Although it's recorded in that order that Xerox copies of documents as per fee is 3.
Yes, my lord.
That's recorded, but here it says only plot information was filed. There's a contradiction apparently. Page 6 of the present impugned order, it states.
It states that however, amendments of the contents of the injunction petition which states
No,
that
that
the
is the second paragraph. The first paragraph says 20th of March 2024, the list of
interim matter was moved with document list under order 13.1.
document list with only plot information.
Yes.
So it says virtually that no other document was filed. And 8th of April, the next list of date, till then no document submitted or supplied. This runs contrary to the recording in the order date.
Or ordered such and such. But so therefore, my lord, if you lost the suppression to what extent that I did not mention the name of my predecessor, from whom the title gathered. They said that Arisa Bibi was the wife of Mursadin. That has been I have mentioned in my plaint. If that be so, my lord, the crux of the finding based on the fact that I did not mention about Arsin, that your lordship find the Royal Lordship's attention to the portion which the specific finding was made. If your lordship can turn to internal page 3. 1, 2, 3, fourth line from the bottom. The defendant took the plea, the Aris Khatian. There are other court tenants as per Aris Khatian. The plot was originally on to Mursalin. During KB stage, plot was recorded in favor of Mursalin in green ink and thereafter honestly recorded 50% in Mursalin and Artisan Bibi in red ink, which has no basis, requires to be determined in court. So our case is that Artisan Bibi's names, which has recorded 50%, has been wrongly recorded. The Mursalin sold the entire suit property to the ancestor of the defendant such and such. The record of right cannot be treated as such and such. So therefore, my lord, our case is that we are not admitting the Arisan Bibi's title over the property in question. Our case is that though the name recorded in the artist record of right, but that is a wrong recording. Mursidin was the original owner of the property. He transferred 61 share to somebody else. Now, my lord, if you logically consider the one thing that next page, my lord, if you logically consider that as per para 9, last line, the plaintiff says legal heirs of Mursidin are not entitled to any suit plot being second party, yet they are made party to the suit. That as plaintiff cause of action as per para 12 against defendant number 1 party, yet this defendant number 2.
Which page?
Next page, my lord, page 4, you will consider from the top.
Yes. Yes, para 9.
Para 7, name of the Salman was changed to Sakina. That as per para 9, last line of the plaintiff says legal heirs of Mursidin are not entitled to any suit plot being second party, yet they are made party to the suit. That the plaintiff cause of action as per 12 against the defendant number 1 party, yet this defendant number 2 party have been made party to the suit. As per amendment, only defendant number 3 party have share in the suit property. It should have been simpliciter injunction suit. As the share of the defendant number 1 party was not disclosed, it was not mentioned. So therefore, my lord,
this genealogical table was given by you at para 16.
Yes. That you are
including those heirs also, the defendant's name.
Page 19, my lord, will find.
Yes, we are looking at that. So this includes them also.
Yes.
So you proceed on the premise that they have title.
Mursalin has the original owner. She transferred to Sakina. That you are page 4, internal page 4.
Defendants also you have included in the genealogical table.
Yes. They are also claiming because our common ancestor is Mursalin.
So the ancestry or lineage you are not disputing.
No.
You are disputing that they have any title.
Any title over the property. Because when page 4, my lord, at the top, you are.
To impede the defendant.
Yes, because my lord, they are claiming to be title about the property, and that is why. If you logically turn to
para 16, you say after PGP was prepared, after presuming the evaluation title also.
yes. And if you look at paragraph 11, what the learned court below was of the opinion, page 17, paragraph 11 of the plaint, your lordship will find. I have categorically said that they have no title. Apart from that, my lord, what prompted me to add them as a party, that your lordship will find. Page 20.
Oh, you have also sought a declaration regarding that.
Yes,
First
my lord.
and second party, they have no title.
Yes, my lord. Even if, my lord, the partition suit incorporates the declaration, that is indivisible.
What application you have now?
Injunction, my lord, not to change the nature and character, that your lordship find my application is at page.
That was the original order path. So virtually you're seeking a stay of this.
Yes, this, but that cannot be the imposition injunction or stay of the final order by imposing the order which was passed at the additive stage. Page 26, your lordship will find my initial application for injunction. Where is that page?
No, we are seeing the first order itself. What was granted.
Yes, first order, your lordship will find that 34. Changing the nature, peaceful poison, and about that, changing the nature and character.
Despite having appeared. Yes. What is your answer to his?
1 to 5 minutes.
What is your answer to his questions? He disclosed in the plaint.
Only one document.
No, this is not a 39-4 situation. Then that pertains to hearing of the main injunction application. Order 39 Rule 4 that they have suppressed anything, or that undue hardship has not been pleaded even by you.
That suppression is.
But suppression of material fact was the premise on which it was vacated. Now we find from their plaint that paragraph 11 they have denied your title. They have in their prayer portion they have also sought a declaration that you have no title, but they have still impeded you because of the mention of your names in the records of rights. Because for abundant caution they have impeded you and sought a declaration that you have no title and sought for partition regarding the rest. They have given the genealogical table also including you, but they have stated there that after presuming evolution of title, although it is erroneously recorded. So everything was disclosed. Where is the question of 39-4?
Subject to correction, my lord. The genealogical table, my lord, relates to the legal heirs of Musauddin, my lord.
Yes.
In that connection, my lord, may I
Yes.
place only one paragraph, my lord, page 38, paragraph 11. 39-4.
This is a part of your 39-4 application.
39-4 application itself.
All right. Yes,
May I read, my lord?
please.
That these defendants states 1 to 5, my lord. Defendant first party, my lord, that the lands of RS and LR plot number 2506, the
Yes. Continue.
corresponding to CS plot number 1590 along with other plots had been recorded in Samil Khatiyar number 50, Hall 48 and 175, 176, 177 and other plots, my lord, Moja, Chunihar, jail number 39 under police station Golbakar district Uttar Dinajpur in the name of Musnuddin. Musnuddin is entitled to the extent of 3624, my lord. They are claiming 100% share, my lord. And rest, my lord, Sheikh Bhakwa, who is not made a party in this suit, my lord, whose legal heirs were not made party, my lord, he entitled 1667 paisa, Sheikh Alimuddin 1667, Sheikh Subratu 1667, and Bibi Asiran 1376, my lord. Bibi Asiran, who subsequently got married with my lord Musnuddin, my lord. And my lord, after the demise of Musnuddin, my lord, the father of the plaintiff, my lord, the son of Musnuddin, and Asiran, my lord, become entitled the share of Musnuddin, my lord. And Asiran Bibi, and whatever share Asiran Bibi got, my lord, she sold out the entire share, my lord. That I have mentioned, my lord, specifically mentioned, my lord. So, my lord, in the plaint, my lord, the plaintiff, my lord, they have beautifully drafted, my lord, by suppressing the material fact that actually these plots, my lord, relates to various persons, my lord. And after, my lord, the rejection, after the order, my lord, which is, my lord, under challenge, my lord, they have preferred, my lord, various applications before the trial court, my lord. For, my lord, amendment of the plaint, my lord, for addition of party, my lord, as per the stand of this answering respondent, my lord, they have taken the steps before the trial court, my lord, for, my lord, addition of party of the rest of the legal heirs, my lord. And they have, my lord, accepted, my lord. So far the KB stage, the green mark and red mark is concerned, my lord. My lord, I have only, kindly, my lord, pardon me, my lord, only one copy, my lord. The learned advocate, my lord, after this order, my lord, filed one application before the trial court, my lord, stating that, my lord, as per the instruction of his client, my lord, he understood that actually
by going through this green mark and red mark, he understood that the property belongs to the ancestors of the plaintiff and the defendant third party, my lord. Kindly, may I place, my lord? The first page only, my lord. They intentionally, my lord, suppress the entire material fact in their plaint, my lord. The first page, my lord.
First page is put up.
No, second page, my lord. The petition. Despite disclosing the entire fact, my lord, in their objection to the, my lord,
This is because of the threat that the court has said.
threat, my lord. But in the
It does
first
not
page,
prove anything.
but my lord, in the first page, my lord, the learned
He
advocate,
stands by what he has stated. He stated that
but
that
he
is.
stated as per instruction of the client. Therefore, my lord, it appears that, my lord,
But in the plaint and the temporary injunction application, he has stated, the plaintiff has stated that these people's names are recorded. But you say Bhokua and Sobratu, Alimuddin, their names are not there.
whatever name appears in the plaint,
But they filed the documents, photocopies of the documents relied on, that is recorded in the first order.
first order, my lord, but they undertake
They must have placed the records of rights also before the
my
court.
lord, they undertake to file the original at the time of hearing, my lord.
Yes, but the
But
photocopies
they
were
have not,
filed.
my lord. My lord, one more document, the addition of party application as per the stand of the, my lord, the defendant number 1 to 5, my lord. They have filed application for.
No, that is
addition of
because
party.
they have stated that you have disclosed certain other names to avoid future complications they are seeking to add them.
My lord.
That does not take away from their initial plaint or make a case of suppression. Since you have mentioned them, they are adding these parties, these persons as parties. That is the statement.
My lord.
To avoid future complications, since you have pointed out, they are also being added.
Lord.
So that it's not unnecessarily bad for none. But that does not amount to suppression of any material fact. They produced photocopies in the first order dated 20th of March. If you please see that original ad interim order. The very first paragraph states that the plaintiff also files a copy of the plaint, power, and Xerox copies of the documents as per Firisti and pay for suit such and such. So they filed the documents that is recorded. Photocopies have been filed. They did not suppress anything. They produced the records of rights. They have made out a case that records of rights are erroneous insofar as certain persons are concerned. And they also seek a declaration in the reliefs of the plaint, that a declaration that these persons do not have a right to the property. But they have made for abundant caution even on the erroneous recording because their names are there. So therefore, what is a suppression? Yes, you have a good case in final hearing of the injunction application maybe. But Order 39 Rule 4, we don't find any ground having been made out. Suppression is the only ground on which is administered.
Suppression so far, my lord.
Why should it be vacated?
They have, my lord, distorted the fact, my lord.
That is, a hearing is required, and the court itself says that for that, a hearing on trial on evidence is necessary. In the impugned order also, court says that somewhere. So please come to the impugned order.
Internal page 5, last but one paragraph.
Page 48.
Internal page 5 of the impugned order, if you please come there.
Last but one paragraph. From the plaintiff's own document, it revealed that
Yes,
Moshiddin
yes.
Shah stands
He
to
revealed that
issue-
Mansudin's share, as stated by Shiksiyas, by which he transferred, is required to prove by trial and evidence. If it is trial and evidence, they are entitled to prima facie triable issue.
My lord, that document is the KV stage document, my lord, which they are relying, my lord.
Yes.
Masnuddin Asiran Bibi's name
These
is
are good grounds for being raised at the trial, not only trial at the final hearing of the injunction application, also by filing. But where is the suppression of it? For coming to a conclusion as to suppression, court has to render findings on the veracity of the documents filed by you and on the effect. They do not suppress that there are others' names recorded in the records of rights. They challenge their title. They say that there is no basis of those recordings. And they disclose that in paragraph 11, 15, 16, they have disclosed that there are others' names. They have implemented them also.
My lord, these others are related to them, my lord, not the defendant, my lord. Kindly have a look, my lord.
Probably not, because if you please
Lordship.
come to the plaint,
My lord.
if you please come to the plaint, page 18.
Lord.
Page 18, paragraph 15 of the plaint. They say about the last 8 lines from the bottom, para 15 of page 18 of their stay application. Para 15. It starts with subsequently, after that green in bold, after that. Subsequently, most illegally and without any authenticity, arrest record was changed and one Ashiran, this is their case. And one Ashiran was shown as the owner of 50%. It is also noteworthy that scan copy of ours does not show. And they say that Ashiran's name was recorded 50%, but they challenge in the next page, there is serious doubt about the authenticity. And para 16, they say it also appeared from L.R. Khatian as per stated erroneous arrest record. L.R. Khatians were prepared after presuming the evolution title of the suit as such and such.
My lord, Asiran is the wife of Muslimuddin, my lord, who is the mother of the plaintiff and defendant third party, my lord. So, my lord, this is, they are just, my lord, they have stated, my lord, relating to their own.
No, your defendant numbers 1 to 5, your names have not been included.
No, nowhere they have stated that I am entitled, my lord, or my ancestors.
No, they are disputing your entitlement.
Yes, and
How can they say that you are entitled? Why should they say that? But you have been imputed as parties and the recordings have been shown, arrest records, photocopies were filed.
my lord, I have placed the document. my
There is
lord.
no suppression at the injunction stage. Thought 39.4 is cannot be invoked. We'll set aside this order of 39.4 and say that we have not entered into the merit of the injunction application and you will be able to canvass all points. But we find that there is no suppression of any material facts entitling you to vacating the order under 39.4.
My lord,
But these are arguable questions in the injunction application and you file a written objection and thrash out all your points. It will be open to the court to decide otherwise also.
the deed number, my lord, which they have mentioned in the plaint, my lord, that they have also filed one application for correction of the deed number, my lord. That's why they have not placed those deeds, my lord.
This is the
Time-
copy which my learned friend received. Enter copy because the means appeal was filed, original document.
The
So
deed
this-
number, my lord.
This
which they
was
have
filed
placed-
along with the plaint.
Yes, this is a file against that appeal was preferred in the, because my lord will find this is order 43 rule wrongly filed, my lord. The document was filed and it was copy was received by my adversary.
Show it to your learned friend. Court is
Lord,
reading.
they are relying on a deed, my lord, which Muslimuddin sold
Yes,
out,
sir.
my lord, to
Maybe that's post
Asiran, my
facto.
lord.
এ দেখুন যখন appeal করা
Don't go on exchanging documents. Keep it with you.
Lordship.
দেখুন আপনার receive করেছে strong objection.
So the records of rights are produced before the trial court. Some other deed by somebody you have disclosed, they are now seeking to add. That does not mean that they have suppressed. They might not have knowledge. They have stated there probably that since you have disclosed, they are implementing.
No,
Must
my
be
lord.
there, first and second paragraph.
Of the plaintiff has stated that one Muslimuddin sold his entire interest. in
Yes,
the suit
read
for
after
the
that.
Plaintiff.
Why they are seeking
The
to?
second, the deed number they have mentioned, my lord, for the year.
Mr. Rai, please find out the relevant. It must be
And
there
the
that since
said
they have.
deed number and date were typed inadvertently due to bona fide mistake. In fact, the correct deed number is such and such. They have changed the
Date-
deed number.
Oh.
Date
subsequent
said,
to
whether
filing.
the typographical error is 1852,
number?
it was said 203.
Deed number, my lord.
There is a
But the original was produced.
Subsequently, my lord, and they have
So
not-
photocopies were produced with the
Produced,
plaint.
it
That
is
is
not
recorded. That is the list.
And there is a list, my lord.
It is here since my senior learned
No,
friend
the court records
Lord.
that all the documents relied on in the print are photocopies are filed. That is the court's. We are not going by Mr. Rai's submission.
No, no.
From the bar, whatever is submitted, he may have wrong instruction.
No,
We are not going by anybody's submissions, but we are going by only the findings of the court. Only. So this is not a 39-4 scenario. We'll record your submission that names of others have been missed out,
Lordship.
omitted, and that they have filed subsequently application for addition of other parties
Third party.
as well as for rectification amendment of the plaint to
And
the
name-
effect that the deed number is concerned.
And name of Sakina Bibi, which they have mentioned in the plaint, my lord.
We'll record that,
Change of
but we'll
name, my lord.
so
Page-
we'll disposing of the appeal itself.
Page 20, your lordship find.
And my lord, kindly, paragraph 11 of my 39-4, my lord.
Yes, we have marked that. We'll refer to that.
Only one thing, my drawing lordship, page 20, we are subject to question, my lord. We have added we have mentioned the person whose name is still L.R. Khatians, That
So you have missed out
20, my lord, can I turn to page 20?
20 we are seeing Sheikh Bokua Alimuddin Sobratu.
Yes, because at present these persons' names are there in the Elar Khatiyar. That is why we have made party, and to what extent?
You have not made them party.
As per Elar Khatiyar, this name is there in that plot. Apart from that, there is no names are appearing at present. That is why I have made party, and according to the share which was recorded. That is why, as my learned friend has
So where you referred to the RS Khotian, you have also not mentioned their names.
no, I have Elar Khatiyar. In terms of Elar,
How you have filed an application for addition of
yes, because they have said that those are the disability accordingly filed an application for abandoned caution. Because the suit should not be defeated on the ground of non-gender necessary parties. That we so.
Mentioned the name, my lord, and they were unaware that who are those persons.
in view of the question involved in the appeal being brief, comma, we take up the appeal for hearing along with the application, comma, to save the parties unnecessary pendency of litigation before this court. Stop. Next para. The challenge, instant appeal has been preferred against an order whereby the application filed by the defendants to respondent numbers 1 to 5 under Order 39 Rule 4 of the Code of Civil Procedure was allowed, comma, thereby vacating the ad interim order of injunction initially granted in favor of the plaintiff stroke appellant on March 20, 2024, primarily on the ground of suppression of material facts.
13.1 to disposed of, my lord, subject to 13.1 to, though it is 13.4, last,
Dispose of.
yes, my lord, last page 53, you will lordship kindly consider page 53. One stroke disposed of.
So that will reopen. We will
Yes, my
say
lord.
that he can take these points in the
Yes,
39.1.
Because primarily, my lord, on 13.4 allowed, that is why 13.1 to disposed of.
There is no independent finding on. You had filed your written objection to the injunction application.
No,
No,
13.4.
no, my lord.
But then the 39.1 could not be disposed of. We'll reopen that, will permit you to file your objection. Next para. By the self-same order, comma, the learned trial judge also disposed of the main temporary injunction application under Order 39 Rules 1 and 2 of the Code. So next para, learned counsel for the appellant argues that the learned trial judge erroneously proceeded on the premise that material facts were omitted, full stop, by placing reliance on paragraphs 11, 15 and 16 of the plaint. It is argued that the plaintiff categorically disclosed the recording of names of the defendants of some of the defendants in the records of rights, but disputed their title and the basis of inclusion of their names in the records of rights. Full stop. Even in the prayer portion of the plaint, comma, such title of some of the defendants has been disputed. Full stop. However, comma, for abundant caution, comma, subject to adjudication, comma, their names were included in the array of parties in the partition suit. Full stop. That apart, comma, learned counsel relies on the recording in order number 1 dated March 20, 2024 to the effect that the plaintiff filed copies of the plaint, comma, power as well as Xerox copies of the documents as per Firisti, comma, which indicates, according to the appellant, that none of the documents relied on in the plaint were suppressed, comma, including the RS records of, including the records of extracts from the records of rights. Full stop. Next para. Learned counsel appearing for the contesting defendants to respondents number 1 to 5 points out that the plaintiff virtually admitted the case run by the contesting respondents in their application under Order 39 Rule 4 by making several applications after passing of the impugned order. Full stop. For example, comma, an application has been made for impleading certain other persons whose names are also recorded in the records of rights, comma, who are not originally impleaded in the suit. Full stop. Moreover, comma, an application has been filed by learned counsel for the plaintiff appearing in the trial court to the effect that he had filed the plaint as per instruction of his client and was not responsible for the statements made therein. Full stop. Moreover, comma, an application has also been filed seeking rectification of a deed number erroneously mentioned in the plaint. Full stop. That apart, comma, it is argued that the parties, that there are several parties on whom title devolved in respect of the subject plots who were not neither impleaded in the suit nor were even mentioned in the plaint or the temporary injunction application, comma, thereby leading to the conclusion of the learned trial judge that there was suppression of material facts. Push up next para. Upon hearing learned counsel for the parties, comma, we find that the primary ground on which Order 39 Rule 4 was invoked was suppression of material facts, comma, since the initial order was passed at the ad interim stage, ex parte, comma, in the absence of the defendants. Push up next para. Entering into the merits of the alleged suppression, comma, we find that the learned trial judge observed that the bulk of the submissions by observed that the deed of 1959 and other documents were not placed before the court, neither it was served to the defendant first party who could have perused the same during submissions. Footstep next para, the learned trial judge further held that the RS was filed later by the plaintiff and by plaintiff apostrophe's own document, his contentions of para 11 of the injunction application is contradicted, comma, which tantamounts to approbating and reprobating in the same breath. Footstep next para, the learned trial judge further observed that the averments and contentions of the injunction application, which states that defendant first party and defendant second party had no right title interest, was intentionally thought out, comma, typed and produced in court, comma, serving copy on the other side in spite of having the documents as per Firisti dated March 20, 2024, which was not submitted to court. Full stop, it was held to tantamount to false affidavit. Full stop. Next para. However, comma, we find from the impugned order itself that the learned trial judge simultaneously observed that from the plaintiff's own document it is revealed that Manseuddin, Manseuddin, apostrophe S share as stated to be 16 annas by which he transferred his total share is required to be proved by trial and evidence in court. Full stop. In the event, comma, in the opinion of the trial judge himself, comma, the matter requires to be proved by trial and evidence, comma, it cannot be a ground for vacating an interim order under Order 39 Rule 4 of the Code. Full stop. To come to a finding that there was suppression of material facts, comma, if detailed appreciation of evidence and further materials is necessary, comma, the same transgresses into the domain of adjudication of the suit or at least the temporary injunction application itself on merits upon taking on record the versions of both parties. Full stop. However, comma, a qualitative finding on merits as to the importance of the material alleged to be suppressed cannot be arrived at the stage of deciding an application under Order 39 Rule 4. In the event, detailed evidence is required to be appreciated for coming to such finding. Full stop. Next para. The suppression of material facts contemplated, suppression of material facts and stroke or misleading statements contemplated in Order 39 Rule 4 has to be palpable and ex facie. Full stop. Next para. We find from the averments made in paragraph numbers 11 of the plaint as well as the injunction application that the right title, interest and possession of the defendant first and second parties have been categorically disputed. Full stop. However, comma, in paragraph number 15 of the plaint and the injunction application, comma, it is clearly disclosed as to whose names are recorded in the records of rights, but it has been pleaded that most illegally, comma, without any authenticity, comma, the RS record was changed and one Ashiron was shown as the owner of 50% of the suit land, and that the inclusion was made after the field survey and the said endorsement of the name of Ashiron was written in red color. Push up, it was also pleaded that such scanned copy of RSROR does not show any date or case number or even an initial or signature of the revenue officer who corrected the endorsement, comma, therefore there is a serious doubt about the authenticity of inclusion of the name of said Ashiran. Full stop. Next para. In paragraph number 16, comma, presuming the evolution of title in respect of the suit land on the basis of the records of rights, comma, a genealogical table has also been given, comma, simultaneously disputing the title of some of the defendants. Full stop. Next para. Consistency is maintained with such stand in the body of the plaint and the injunction application in the relief sought in the suit, comma, in particular prayer B thereof, small b thereof, which is a declaration that the defendant first and second parties derived no title or any right to possess the suit plot, and the RS and LR records, LR, ROR are erroneous, comma, wrong and not binding upon the plaintiff, and such recording does not extinguish the title of the plaintiff over the suit land. Full stop. Next para. In conjunction with such averments, comma, in order number 1 dated March 20, 2024, comma, the learned trial judge categorically recorded that the plaintiff filed copies not only of the plaint and the power, but also Xerox copies of the documents as per Firisti Y diye shesh. Full stop. Next para. Hence, comma, as per the recording in the said order, comma, in the view of the learned trial judge as well, comma, the documents referred to and relied on in the plaint and the injunction application were filed in photocopies at the time of filing of the plaint itself and at the juncture when the ex parte ad interim injunction was granted. Full stop. Next para. Learned counsel for the contesting respondents relies on paragraph 11 of the Order 39 Rule 4 application in particular by pointing out that the names of some parties disclosed there were also depicted in the records of rights but were not included as parties. Full stop. Such stand is sought to be bolstered by arguing that the plaintiff subsequently filed applications for impleadment of such parties, comma, thereby corroborating the case of the contesting respondents. Full stop. Next para. However, comma, on a perusal of the said application, comma, which was handed over to court momentarily for the purpose of such perusal, comma, it transpires that the plinth of the said application is that since the defendants have mentioned the name of certain additional parties, comma, they are being impleaded for abundant caution. Full stop. Next para. Insofar as the application for correction of a deed number is concerned, comma, the date of the deed was correctly mentioned in the plaint and the injunction application, but the number thereof was erroneously stated. Full stop. Thus, comma, we do not find any suppression of material fact worth vacating an order coming within the purview of Order 39 Rule 4 of the Code of Civil Procedure. Full stop. Next para. However, comma, we insert a caveat here to the extent that all the issues raised by the contesting defendants stroke respondents will be open to be taken by them and the other defendants at the time of final hearing of the temporary injunction application. Full stop. Next para. The respective scopes of Order 39 Rule 4 with regard to an ex parte ad interim injunction and at final adjudication of a temporary injunction application under Order 39 Rules 1 and 2 are different. Full stop. The former is restricted to the parameters laid down in Order 39 Rule 4, whereas all questions are open to be canvassed by the parties at the final hearing of the temporary injunction application, comma, since the pleadings and documents of both parties are before the court at that juncture. Full stop. Next para. On the test on the anvil of the yardsticks of Order 39 Rule 4 in respect of an ex parte ad interim injunction, comma, however, comma, we do not find such tests to be satisfied in the present case sufficient to vacate the initial ex parte ad interim order granted in favor of the plaintiff appellant. Full stop. Next para. Accordingly, FMAT 449 of 2024 is allowed on contest, comma, thereby setting aside the তার আগে আরেকটা কথা এই লাস্ট সেন্টেন্সের আগে একটা কথা. Another aspect of the matter cannot be overlooked, full stop. The learned trial judge, comma, even prior to filing of written objection by the contesting defendants, comma, disposed of the temporary injunction application itself by the impugned order without giving both parties opportunity to address the same on merits, comma, consequentially upon the allowing the application under Order 39 Rule 4 of the Code. Full stop. Such approach is completely erroneous and contrary to law, comma, since the allowing of an application under Order 39 Rule 4 only pertains to the ex parte ad interim order granted initially and not to the final adjudication of the injunction application, which is to be heard and decided independently. Full stop. Next para. Thus, comma, the impugned order is bad on such count as well. Full stop. Next para. Ever. Accordingly, FMAT such and such is allowed on contest, thereby setting aside the impugned order bearing order number 5 dated May 15, 2024 and reimposing the ad interim order of injunction granted on March 20, 2024 by the learned civil judge, Senior Division, Islampur, District Uttar Dinajpur in partition suit number 134 of 2024 till disposal of the temporary injunction application. Full stop. The contesting respondents shall file their affidavit in opposition, file their written objection to the temporary injunction application in the trial court, if not already filed, comma, within a fortnight.
Some more times. Election is going on.
So,
Lordship, advocates are also please.
how much time?
6 weeks.
Shall file the written objection, comma, if not already filed. Full stop. On the prayer of learned counsel for the contesting respondents, comma, the time for filing written objection is granted for a period of 6 weeks from date. Full stop. Next para. It is expected that the learned trial judge shall dispose of the temporary injunction application as expeditiously as the business of the said court permits thereafter. Full stop. Next para. We reiterate that this court has not entered into the merits of the temporary injunction application and it will be open to the learned trial judge to decide the same independently in accordance with law, comma, without influenced in any manner by the observations made above on the merits of the said application. Full stop. Next para. Can 1 of 2025 is consequentially disposed of as well, no address to cause urgent settlement. Thank you. Thank you.
My time for the applicant.
Yes, Sarpin, what is the
There
matter?
was a caveat, my lord. We have sub copy, my lord, to the caveat, my lord. It's the affidavit of service.
Yes.
This is a suit for eviction of a trespasser, my lord, and my lord, recovery of possession. In the suit, my lord, they claim, my lord, that they have obtained the property, my lord, in the year 1970.
You are the defendant.
But I am for the defendant, my lord.
Lost in both courts?
No, my lord. Initially, the suit proceeded ex parte. First court, my lord, the degree was degree of reversal, my lord. Trial court is in my favor, my lord. Trial court said that you could not establish your title in the suit property, so you cannot claim that you want eviction. But after that, appeal court had reversed, my lord.
Why did the appeal court reverse?
The appeal court reversed, my lord. The trial court held, my lord, 2 points, my lord. First point, my lord, is that, my lord, that they claim in 1977 they obtained the gifted from Narayan Chandra Chaudhary, who is the original owner. Thereafter, in 1985, my lord, they had given tenancy to my predecessor, my lord. And thereafter, my lord, again it was extended, my lord, in 1998. Until 1999, he said that he is taking rent from my client. Now, my lord, what happened, my lord? The petitioner stated, the court held, my lord, that if
these are admitted in the plaint, what you are saying now,
yes.
all of these are admitted.
I'm stating from the plaint, my lord.
So up to 1999, they admitted it to rent from your predecessor.
Yes, my lord. That I have paid, my predecessor has paid rent and thereafter I made default.
Acha.
Now, my lord, subsequently, he has died on 29th
So
December 2008.
they relied on section 2G.
No, my lord.
How-
They said
become a
that we
trespasser?
to be a trespasser.
How?
They said,
You are the
Trespasser.
admittedly the heirs of your predecessor, the
but
original.
my lord, they have also given me a notice under section 6(4) for eviction. My lord, in one hand, they are saying that I am a trespasser.
That
and
is the plaint, Mr.
yes, my lord. Page 10, my lord, of my stay application.
How are you related to the original tenant?
But I am the legal owners, my lord. My lord, I am the
Wife and
sister.
children.
No, my sister, my lord. He has died useless, my lord. And but the two.
So you are the heirs.
Yes, in that way, my lord. And this is my
They have
lord,
not pleaded specifically 2G, but they have stated that after 29/12/2018,
kindly,
they gave
my
you a
lord.
notice under section 6.
Yes, para 7. Kindly see, my lord, para 7. That the plaintiff stated that the original tenant was a bachelor and he died on such and such, that immediately thereafter the tenant in question, or of commerce, automatically come to the end and the relevant provision of time, West Bengal Process State as amendment, particular section 6(4), tenancy amended.
Let us see how the appeal court proceeded.
My lord.
Let us see how the appeal court proceeded.
Yes, my lord. But kindly comes to my lord, near page 9 of the appeals court judgment, my lord.
Trial court said they failed to prove title even.
Yes, because my lord, they said they have produced, my lord, a certified copy of the lease deed, my lord, and but they have not produced any witness from the.
What other ground trial court refused?
But first, that you could not produce your title, and second, this title could say, my lord, that if you are the owner from 1977, then when 1988, when he get the tenancy, why your name is not there in the tenancy agreement? But the person, my lord, who is giving tenancy agreement, my lord, he is in 77, he become owner, my lord. Then, my lord, subsequently, if he is becoming owner, the tenancy, the ownership transferred. So
1985 tenancy was given again.
Yes,
tenancy was given, but his name is not there.
1985 tenancy agreement was given. No, his name was not there in the agreement.
His predecessor interest name was given.
Yes, predecessor interest was given.
There was a tenancy agreement.
Yes, my lord, tenancy agreement. So court did not believe him. Court said that it may be an ex parte degree, but you have to prove your case.
Definitely, yes. So yes, how did the appeal court reverse it? Let us see.
Yes, my lord.
Page 9.
The appeal court, yes, sir. From inner page, but after going through the impugnation
with reasons from page 11, that is.
Yes, but page 9, my lord, he has recorded of everything what has been recorded by the trial court.
Achha.
But whatever I am saying, my lord, then my lord, argument was advanced, but similar argument that how 6(4) can be given. This was argued by us, my lord, in the trial court. But there, my lord, after, my lord, kindly see, my lord, proof of ownership. The court also accept that proof of ownership is required. But my lord, the evidence of thereafter he said about evidence of possession. What are required, my lord? He is saying that only. My lord, your lordship will find effective, my lord, what his decision, my lord, from my lord, page 13, my lord, the last paragraph, in the instant matter. That is the only finding, my lord.
The rest is theory.
Yes, rest are all theory, my lord.
Yes, in the instant matter.
What he said, what the trial court said, and what should be done thereafter this thing.
He produced the gift deed.
give deed, my lord, but that deed was not proved, my lord, because it was a certified copy. He has not produced a witness from the register to prove that deed, my lord. On that ground, my lord, the trial court has to, it's not accepted that one. He said, my lord, it's not required. And regarding 6.4, he said that wrongly served that notice.
This second appeal will be heard on the following substantial questions of law. 1. Whether the learned judge of the first appellate court substantially erred in law in reversing the dismissal of the suit by the learned trial judge by overlooking the admission of the tenancy of the defendant/appellants by the plaintiff/respondent by issuance of a notice under section 6 within bracket 4 of the West Bengal Premises Tenancy Act 1997, and in view of the utter absence of any explanation in the plaint as to how the tenancy granted to the predecessor in interest of the defendant/appellants, which, under the law, gave rise to a statutory tenancy in favor of the defendants/appellants on the demise of the original tenant, got converted to unlawful possession by the defendants. Next, whether the learned judge of the first appellate court substantially erred in law in reversing the findings of the learned trial judge insofar as the absence of proper proof of the document of title of the plaintiff/respondent is concerned, in view of the fact that no original gift deed in favor of the plaintiff was produced, but merely a certified copy thereof, without proper explanation as to why the primary evidence could not be produced. Next, whether, in view of the suit being initiated by issuance of a notice under section 6 within bracket 4 of the West Bengal Premises Tenancy Act 1997, the learned first appellate judge substantially erred in law in decreeing the eviction suit without any of the grounds as stipulated in section 6 of the said act having been established. Yes. The stay application is taken up for hearing. They have levied execution.
Yes, my lord. When we have filed this my lord, to appeal, my lord, there was no execution, my lord. Subsequently, my lord, they had filed an execution case, my lord. That is OC.
We take up the application for stay. Affidavit of service filed to be kept on record. Despite service, none appears for the caveators. Accordingly, we take up the stay application for consideration of grant of grant of ad interim order. Next para, since the second appeal has been admitted on the above substantial questions of law, we find sufficient prima facie case having been made out. Since we are also informed that execution has already been levied, thereby giving rise to urgency in the matter. Accordingly, there shall be stay of operation of the impugned judgment and decree dated October 31, 2025, passed by the learned additional district judge, fast track second court at Malda, district Malda, in OC appeal 11 of 2023, and as well as stay of all further proceedings in the connected execution case till disposal of Can 1 of 2026. Next para, the respondent shall file his affidavit in opposition to the application within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. Liberty to mention the application for inclusion in the list. after the above timeline for filing of affidavits is over, for sub next para, the question of imposition of occupation charges is being kept open for being decided at the final hearing of the application. For sub next para, the learned advocate on record for the appellants shall forward a server copy of this order along with a covering letter intimating the gist of the same to the learned advocate appearing for the respondent caveator within a week.
Grateful.
Next. Yes.
There is a can two, my lord. This is 6 and 5 application of delay of 38 days, my lord.
Serve.
No, my lord. May I serve and come back, my lord?
The appellant shall serve copies of Can 1 of 2025 as well as Can 2 of 2026 on the respondent, indicating that the matters shall be listed under the same heading in the monthly list of May 2026. Next. When an affidavit of service shall be filed to that effect by the appellant.
18 will die.
Yes. You are for the respondent.
চশমার খাপটা একটু ফেলে গেছে কেউ কিছু রেখে দেবেন পরে কেউ এসে নিয়ে
Scott, what is the matter? Section 5 was previously allowed.
Yes, Lord, it has been allowed. Lord, it concerns, Lord, a premises number 3/1 Hesham Row. I have purchased this property, Lord, under a surface action bank sale. Now, Lord, post possession, Lord, when around October 2023, Lord, I found that there was an invasion in the property by the respondent. They had trespassed into the property and Lord, they were claiming a portion of the property. This area is about 15 kata, 8 chata, 29 square feet. That is the sale certificate which I got from the bank and there is a conveyance registered in my favor. Now, Lord, this invasion or Lord, this trespass was objected to, a suit was filed. An interim application was filed under Order 39 Rule 1 and 2 and Lord, the court passed an order. If your lordships kindly, Lord, initially, Lord, the trial court refused to pass an order. Then we came up in appeal. The appeal court on contest, Lord, passed an order, which is at page 370, volume 3.
Yes.
Lord, if your lordships, Lord, kindly comes to page 372, where decision with reasons are there. May I just place this part? The learned advocate for the appellant argued the second paragraph after decision with reason that admittedly this appellant is the owner of the suit property. His name has been duly mutated. He has prayed for injunction in respect of C schedule property only. According to him, his respondent was another bidder in the auction but became unsuccessful. In fact, the opposite party, the respondent, Lord, they participated in the bidding process.
Yes, you said that.
If the respondent has any grievance against the auction purchase, he may ventilate his grievance before the DRT under SURFACE Act, but this respondent is trying to disturb the appellant by changing its face through different people. On the other hand, learned advocate for the respondent argued, Lord, the scope of the argument, if your lordship kindly turns the page, third paragraph, in respect of C schedule property. There is no order of injunction against the respondent or anyone in connection with the other suit. From the annexure, it is apparent that the appellant has acquired the suit property by auction purchase from Indian Overseas Bank. Mutation certificate shows that on the strength of the said purchase, the property has been recorded in the name of the appellant. From the order of Deputy License Officer KMC, heard on the basis of the order of the Honorable High Court, Calcutta, dated such and such, it is explicit that the certificate of enlistment in favor of Messrs. Unani Conclave Private Limited, this is not another party, is cancelled and it has failed to produce any valid identity and proof or occupancy, etc. It may not be out of place to point out that no document of irrevocable license is filed showing the erstwhile owner of the said property had granted any such irrevocable license. I do not find any material, even prima facie, to come to the conclusion that the respondent has any sort of right, title and interest in the suit property or in any portion thereof. On the contrary, it seems to me that the appellant has got good ground to go to trial. As he has already invested huge amount in purchasing the property, it appears to me that the balance of convenience and inconvenience tilts in favor of the granting injunction.
Yes, Mr. Court, we have briefed you. Right. Yes.
So, my lord, after this injunction, the matter was challenged, my lord, this order was challenged under Article 227. If your lordships kindly come to page 383. Lord, if your lordships kindly sees the second paragraph. There was a recording of the fact that we will not carry out any construction in the suit property and the nature and character of the property shall not be changed during the subsistence of the aforesaid revisional application. Now, Lord, this is still pending. This is still pending. This is still pending. Now, Lord, during the pendency of these proceedings, Lord, a title suit is filed seeking declaration and injunction by the respondent who was a defendant in that suit. Now, my lord, in that, if your lordships kindly take the plaint at page 492, the fourth volume. Lord, paragraph 3, it starts at page 492. Kindly come to 493.
Yes.
Paragraph 3. The plaintiff was granted a perpetual tenancy by the original owners of the suit property. The arrangement permitted the plaintiff to use the land as a playground for guardians to wait during school hours. The plaintiff had full uninterrupted access to the property during such time with the knowledge and express consent of the original owners. Not the original owners, I'll give your lordship the name. There were 3 owners: Mehul Overseas Private Limited, Kundan Investment and Prime Global Private Limited. There were 3 companies who obtained, Lord, the loan against mortgage of the property from the bank. Continued in occupation and open, peaceful, conferring upon its equitable possessory right. Copy of the agreement. Perpetual tenancy is annexed. Then, Lord, in paragraph 4 and 5, Lord, they talk about, Lord, the sale, their participation. Then, Lord, paragraph 6 to 9, they challenge the procedure followed by the bank under the SURFACE Act, conducting the sale. And then, Lord, paragraph 10, if your lordship sees, says that on 30th October 2023, this date is also, Lord, not disputed, when the defendant number 3 issued a letter claiming to be the owner of the property. By the same letter, defendant number 3 alleged that the students were found playing in the said property and directed plaintiff not to trespass the property. It was further stated that some unscrupulous persons were attempting to deal with the said property while creating lease in respect thereof, etc. And then, Lord, your lordships will kindly come to paragraph 12. This is not the earlier suit he is talking about. 12, 13, your lordships will find this is not relating to earlier suit. Then paragraph 14, they challenge the transaction of sale in my favor. They say that this is tainted by fraud from inception, etc. And Lord, ultimately, the fraud is also pleaded in para 17. These are all, Lord, on procedural irregularity under the SURFACE Act. And ultimately, your lordships will see the prayers at 501. declaration, that Lord, cancellation, first Lord, the cancellation of the deed of sale, and then Lord, declaration, permanent injunction from claiming any right, title and interest in the premises. And your lordships may kindly see page 502, the schedule of the property. They are claiming their right in respect of 3 kathas out of 15 kathas. Around the middle, your lordships will find 3 kathas. Now, Lord, in the Order 39 application, if your lordship looks at the prayers, Lord, it is at page 421. That is Lord, volume 3. This is Lord, the prayers in the Order 39 application. 421. The changing of nature and character is not included. That was not pleaded in the original plea. The prayers in the plaintiff is 501.
This was filed after the revision,
after the
revisional court.
revisional court order. This was not filed in 2025. The revisional court's order was on 16 December 2024. Now, Lord, the impugned order, if your lordships kindly takes page 554, that's the last volume. Your lordship can come to page 563 because Lord, the facts can be avoided.
Yes.
There's a heading called decision. This is a suit for declaration that sale certificate dated 30th June 2021 and registered deed of sale dated October 8, 2021 issued and executed by the defendant number 1 in favor of the defendant number 2 in respect of the suit property is illegal, void and are to be cancelled. Plaintiff also filed an application under Order 39 Rule 1 and 2, etc. Kindly come to the second last paragraph. I have heard the respective arguments of the parties and considered the materials on record. Admittedly, the suit property belonged to Messrs. These are the 3 companies who mortgaged the suit property with defendant number 1 bank to secure credit facilities, but as they failed to remit the loan taken by defendant number 1 bank, being a secured creditor, became the absolute owner of the suit property, and defendant number 1 under auction issued sale certificate in favor of the defendant number 3 and executed registered deed of sale being such and such. So and so, plaintiff challenged the suit on the ground that the deed of sale has been obtained by fraudulently, etc. On the contrary, it is the case of the defendant number 3 that the defendant number 3 came into possession of the suit property by virtue of the said registered deed of sale executed by the defendant number 1 and is the absolute owner of the property, and the plaintiff herein has been restrained not to cause any disturbance with the possession of the defendant number 3 in the respect of the suit property. Then it is to be mentioned that despite being served with a notice, defendant number 1 and 2 did not turn up, and the temporary injunction application is being heard ex parte against the defendant number 1 and 2. The defendant number 1 and 2 is the bank and the bank's officer. Both plaintiff and defendant number 3 annex photocopies of documents with the temporary injunction application, written objection, etc. executed between Messrs. So and so. Agreement of tenancy dated January 4, 2016. If your lordships kindly mark this, I'll just show your lordship this agreement. This document prima facie suggests that plaintiff is a tenant in respect of the suit property. Plaintiff also filed photocopy of second sale notice dated such and such issued by the defendant number 1 bank for sale of suit property herein. And in that sale notice, defendant number 1 stated that the suit property was mortgaged to defendant number 1, and defendant number 1 through its authorized officer to possession and will sell the property as is, where is, as is, or what is, whatever there is basis. The property is a tenanted property and under the bank symbolic possession. Under the said sale notice, it is prima facie clear that the defendant number 1 bank was never in physical possession of the suit property and was in symbolic possession of the suit property, and the possession of the suit property remains with the plaintiff tenant. Therefore, from these documents, it is prima facie established that the plaintiff being a tenant in suit property is in possession there. Then, Lord, my sale deed is considered. My defense that civil court has no jurisdiction. This is a surface action, and there is a bar under section 34. Lord, is taken note of, but the court says that since there is allegation of fraud and challenge of sale is on the ground of fraud, therefore, Lord, the court can interfere. And Lord, ultimately, page 567, the ordering portion. But in fact, 566 last two paragraphs may kindly be taken note of. Page 566, last two paragraphs. Now, Lord, the right that has been pleaded is based on a tenancy. The case as argued is that we are a tenant, therefore mortgage or no mortgage, there is a valid tenancy, our rights are not affected, and bank was in symbolic possession, not in actual possession. Therefore, so sale was on as is where is basis. Possession was not, bank was not in possession, therefore the purchaser was not in possession, and consequently, Lord, this order of injunction is given. Now, Lord, your lordships may kindly consider the tenancy agreement first. The tenancy agreement is at page 485. No, sorry. 425. I'm sorry, Lord. I page 425, volume 3. Kindly, my lord. I'm sorry.
We'll come back to start with. You are for the respondent.
But I was placing the tenancy agreement,
Right.
which was part of the plan, starts at page 425.
Right.
Your lordships kindly, my lord, first mark the date of the creation of tenancy.
4 January 2016.
2016.
Yes.
And then, Lord, kindly take note of two other facts. Lord, please come to page. Just a minute. Page 429.
Yes.
Lord, the demise premises is the schedule under the agreement. And Lord, clause 3, if your lordship sees that tenant deposited 11,000 security deposit, and clause 4 is the rent. And the schedule speaks of 3 quarters of land. If your lordships kindly come to page 430. And kindly see, my lord, who are the person who's creating this tenancy. There are 3 persons at page 425, Prime Global, Mehul Overseas and Midnight Merchants.
Yes.
These are the 3 companies who were the original borrowers.
Mehul is formerly Midnight Merchant.
Oh, sorry. Formerly. The
That one
next-
is Kundan.
Kundan is in next page.
Yes.
So these are the 3 companies, my lord, who were the original borrowers. Now, my lord, vis-a-vis this, I'd request your lordships to kindly come to page 436 once. This is, my lord, the sale notice. For our purpose, kindly come to 441. Please come to page 441.
Yes.
This is the public notice for sale of immovable property. Lord, what is important for us is kindly see the date of NPA in the table. Your lordships will kindly see the table. First is the date of NPA.
Yes.
31st March 2011. Then, Lord, demand notice, that is, Lord, 13.2 is 13th May 2011. And, Lord, date of possession notice, that is 13.4, is 18 July 2011. 2016 is post these, Lord, actions. Now, Lord, the first point is whether, Lord, prima facie, this tenancy is sustainable. If your lordships, Lord, kindly take the Securitization Act once. That is it. Okay. Do I hand over, my lord? We have extra copies.
Should be there. Yes.
Lord, please come to section 13, subsection 13 first. Which says,
yes,
no borrower shall, after receipt of notice referred to in subsection 2, that is 13.2, transfer by of sale, lease or otherwise, other than in the ordinary course of his business, any of his secured assets referred to in the notice without prior written consent of the secured creditor. So, Lord, admittedly, I stop, Lord, saying that it's a sham document, but, Lord, admittedly, even if this document is taken note of, there is no tenancy in the eye of law. Number 1. Number 2, Lord, when the incident happened in October 2023, when this incident, Lord, happened of trespass in 480 in October 2023, Lord, we had given a letter to the school. If your lordships kindly, Lord, takes that letter at page 485. Kindly come to volume 4. Please come to page 485. If your lordships will not kindly come to the last two paragraphs. Today at around 3 p.m., I think, or 1 p.m., it has come to our notice that the knowledge that some children, student of your school, have entered into the aforesaid property and they were playing and or doing other co-curricular activities on our aforesaid property. We would like to inform you that some unscrupulous persons are illegally trying to deal with the aforesaid property, which wholly and solely belongs to our above named company only, and the said persons are also illegally trying to lease it out to or let out the aforesaid property or parts and or portions thereof to third parties based on some fabricated documents, false and fabricated documents. These acts of the aforesaid persons are not only violating our legal right, but also violating our fundamental right. Then, Lord, please come to the last paragraph. In view of the aforesaid circumstances, you are hereby directed not to trespass and or encroach onto our aforesaid property and or refrain from using our aforesaid property and or any part or portion thereof, and restrain your students, associates, men, servants, or agents from entering and or using the aforesaid property or any part or portion thereof in any manner whatsoever or howsoever, as we being legitimate owners of the entire property. Now, Lord, there is a reply to this. Your lordships will kindly take the reply at page 488. If your lordship please turn the page, come to the second page of the letter at page 489. Kindly, Lord, take the first paragraph. In such circumstances, the allegation or any unscrupulous persons illegally attempting to deal with the property has no basis whatsoever and appears to have been made and concocted with some sinister design. In this connection, be it recorded that owing to obstruction from our co-tenant, namely Unani Conclave Private Limited, despite the subsistence of our lawful tenancy since January 2016, we could not physically use or utilize the same, as we always intended to avoid any undue hassle or dispute considering the safety and security of our students and staff. So 2016, since 2016, they said they were not using the property. However, after prolonged negotiation, we have been able to impress upon Mr. Mahesh Singhania of Unnati Conclave Private Limited. We don't know, he has no connectivity with the ownership of the property.
Co-tenant, they say.
Co-tenant, they say.
In the deed, lease deed, Unnati was also one of the.
Unnati was not. In fact, we had initiated the proceedings against Unnati in a separate suit because blood of trespass, etc. That is a separate chapter. Now Unnati has moved out from the property. That's not relevant for our purpose.
Since September 2023, they could beneficially use.
So, Lord, we say that in October you have trespassed into our property. The reply says that yes, 2016 onwards we were not using it. We entered the property in September 2023. Now, Lord, on these facts, whether, Lord, the trial court was justified in concluding that they had a right in their favor. Because, Lord, I'll come to the question of whether the sale being proper or not, or that my right is there or not. That will be ultimately decided in the suit. If my title deed goes, if a sale certificate goes, that's a separate chapter altogether. Today, Lord, we are only concerned about whether they have a right in the property. The property which has been sold by the bank to me, I'll show your lordship to those documents. Those are, Lord, insofar as I am concerned, I have acquired the right from the bank. Whether, Lord, bank was in possession, I was in possession, all these issues are irrelevant for the purpose, for our purpose, until such time the school shows that they were legally in possession of the property. at least in respect of the 3 cutters. The only right they show in respect of this property is that agreement of 2016. And I'm showing to your lordship, Lord, from the documents, admitted documents on record, that Lord, 2011 13-2 notice was issued. 13-4 notice is also 2011. NPA is prior thereto. So, Lord, where is the question of creating any tenancy by the borrower without the consent of the bank? So, Lord, this is, Lord, the right on which, Lord, the plaintiff has come to court. Now, Lord, a little submission, Lord, on the sale of the property. If your lordship, please come to page 436 or 441, the page that your lordships were looking at.
Yes.
Sorry, 436. Your lordships may kindly come to 436. Yes.
Yes.
Look, please come to page 436. Lord, reliance is placed on the paragraph, Lord, which is immediately after the table, 2 paragraphs after the table.
As is varies.
As is where is whatever there is basis. Now, Lord, if your lordships kindly look at the Securitization Act once again and come to the rules of 2002.
Yes.
Lord, your lordships will find Appendix 4A, which is, Lord, the appendix for the sale notice. Lord, this is the prescribed sale notice under Appendix 4A. The lordships will find that it prescribes that as is where is whatever there is, as is what is basis. Now, Lord, this is the prescribed notice prescribed for pro forma on which the sale notice is being issued. And Lord, this is the basis on which the offers are invited. Now, Lord, I'll show from one of the judgments of the Supreme Court where this has been explained. What the Supreme Court says is that when this is mentioned, the seller does not take the encumbrance attached with the property. That means the tax that is to be paid on the property or the electricity dues if it was a factory electricity dues. But this has no reflection on the property itself. So far as the status of the property is concerned, it's a buyer beware situation where the buyer will have to, he is put on notice that he has to make adequate inquiries, etc. But not, the bank is not going to take the responsibility in so far as this aspect of the matter is concerned. And Lord, followed, Lord, when the sale was conducted, I was declared as a successful Lord purchaser. The sale certificate was issued, which is in Lord in volume 1, page 52. কোনটা থেকে দেখো? Lord, is it legible?
Yes.
There is another page. ওটা ভালো না? But what I wanted to show is that after এখান থেকে পড়া যাচ্ছে। Lord, if your lordships kindly Lord sees after the consideration that is mentioned around the middle of
Yes.
your lordships will find it says the sale of the scheduled property was made free from all encumbrances known to the secured creditor. But they are also challenging Lord the conveyance because they are asking for setting aside of the conveyance. And Lord, the conveyance starts at page 65. Sorry, ঠিক ভুল বলছি তো কোথা থেকে আরেকটু আগে থেকে বলো sorry Lord, it starts at page 57. Sorry. But what is being emphasized on our possession is that the clause J at page 65. Clause J at page 65. Your lordships Lord kindly takes clause J, where it states in bold letters, certificate of sale under Surface Act. Has your lordship got that? Dated such and such has been issued by the authorized officer, secured creditor vendor, and further authorized officer or secured creditor vendor have handed over deemed possession of the secured assets. Deemed possession is what is being commented upon. More fully described in the schedule hereunder, to purchaser, vendee, or as is where is, whatever there is basis.
So deemed possession.
Deemed possession. Now, the kindly Lord come to page 67 also.
Yes.
Lord, this clause 3 is also being commented upon, where they said that purchaser vendee shall not claim any right of occupancy possessory in respect of the said secured assets more fully described in the schedule hereunder in future. There are two things. One is deemed possession, and Lord, I cannot ask from the bank for right of occupancy. This is Lord what is being harped upon. But clause 5 says that I'll be responsible for all future outgoings, etc. And clause 4 also says that secured creditor vendor has agreed that he shall have no objection or whatsoever nature in transferring all the right title and interest and shares in respect of the above said secured assets more fully described in the schedule hereunder name of the purchaser vendee in future. There is a letter Lord at page 74. That is, of course, written by us. Lord, you can ignore that. Now, Lord, there are two things. One is creating a cloud as to the possession, because Lord, the conveyance gives me the right title and interest. There can't be any two opinion about it. Only clout is whether I am in possession.
What is the ground of fraud there on which they are challenging this?
Fraud is, they say that proper procedure under the Surface Act has not been followed. I'll take your lordship to that paragraph in the plaint. Now, my lord, as I said, that it is one thing to say that title, you have a title, but you don't have possession. But that does not prevent me from filing a suit defending my title and also was proceeding against a trespasser if the trespasser, my lord, gets into my property.
You're talking about your suit.
My suit. My suit, in my suit, there is a protection order that has been passed. That order has been carried into 227. In the 227, Lord, we have given an undertaking that we will not change the nature and character. We will not make any construction. That is the undertaking given, that proceedings is pending. But that order of the appellate forum is still in force.
Yes.
Now, Lord, there in that order, in the appeal court order, there is a clear finding that I am in possession. Right, wrong, indifferent, that will be decided in that proceedings. The additional suit that has been filed, in the suit that he has filed, he is seeking cancellation of the sale certificate, cancellation of my document, conveyance. These are the two primary relief in the plaint. And he is saying that maintain.
In the suit, injunction has been sought regarding that you may not give out your title on the basis of the deed.
Yes.
And in the temporary injunction, they have added transfer, change of nature character also.
Okay, yes, changing nature and
character.
Change in nature and character.
But in the injunction also, what injunction has been granted against you pertains to, we saw status quo probably has been given, not only confined to nature character, but also possession.
Possession.
But that was not there prior in the injunction application.
Right. And apart from that, your lordships may kindly come back to the plaint once and kindly see the prayers first. Lord, page 501.
Yes.
Now, Lord, unless the suit succeeds in terms of prayer A and C and the consequential prayer of B, Lord, my title, right title and interest in respect of the property does not get affected at all. Therefore, Lord, this C is really consequential on A. Unless, Lord, my documents are set at naught by the court, Lord, this injunction, even at a temporary phase, it can't be granted.
But in a temporary injunction application, Mr. Court, they can improve upon their plaint case or ask for more injunction also, provided it is in aid of the final outcome of the suit.
Right, right.
So
and
may say that you please don't alter the nature and character without the please. Don't alter the nature and character of the suit property, because that is in aid of the relief which I am seeking in the suit. If I get a relief in the suit, they get a relief. Then
Lord, my submission is that,
yes,
Lord, today I have an absolute title to the property.
Yes, undoubtedly. Unless
their suit succeeds. The success of suit is based on para 17 of the plaint. Your lordships may kindly see para 17. This is the fraud that they allege. May I just place, Lord, the 4 or 5, 8 grounds that they say. First is plaintiff was excluded from the auction process by refunding the earnest money deposited by it on 2 occasions and by issuing the second sale notice in obscure newspaper in violation of statutory rules which mandate that the publication has to be made in leading newspaper with wide circulation.
What were the obscure newspapers in which it was published?
This ki kagojta chilo?
Anyway,
there was some newspaper that the bank had produced.
What words remember?
This is one. Number 2 is the plaintiff's interest to purchase the said property was known to the defendant number 1, and it was in constant touch with the bank and had expressed its consistent interest in purchasing the property. The second sale notice was not affixed at the said property, which is mandated by the statutory rules. The documents record that the said property is tenanted and disclosed only symbolic possession has been handed over to the defendant number 2 without any future right of claim of possession. The plaintiff was in constant contact with the
This is
defendant.
their interpretation of that clause 4.
Clause 4. Now, my lord, the basic point, as I made, because of section 13, subsection 13, this document could not have been looked into by the court until
At the plaintiff, they have to prove their title to the property. They don't have any.
Correct.
In view of that document transferring no title due to the bar of 1313. That is your first
submission. My second submission was that this suit was not maintainable in the civil court because of section 34.
Yes.
Yeah. Please see section 34. They are challenging a sale that was conducted under the surfacing. So, my lord,
say anything relating to any of the measures under that act
comes under section 17.
17?
Yes.
And that read with section 34, there's a bar.
And section 17, Lord, clearly says that any person.
Yes.
It says any person, including the borrower, aggrieved by any of the measures. Your lordships may kindly see section 17.
Yes, any of the measures. Their suit is clearly on the measures.
On the measures. And that's why I placed
independent declaration of title.
Absolutely.
Very good.
And therefore, Lord, these are the basic grounds on which, and Lord, I say that so far as the creation of tenancy is concerned, that is barred by law. The document of 2016 is barred by law. Therefore, Lord, that tenancy could not have been created. And in fact, your lordships will find from the order of the appellate court passed in my suit, this document did not surface at that stage. They only claim that they have perpetual license to be in the property. If your lordship kindly, Lord, goes back to that order once, page 370. Kindly come to page 373. Last paragraph.
Irrevocable license.
It may not be out of place to point out that no document of irrevocable license is filed showing that erstwhile owner of the said property had granted any such irrevocable license. I do not find any material, even prima facie, to come to a conclusion that the respondent has any sort of right, title, and interest in the suit property. At that stage, they did not disclose this document, if this at all existed as on that date. And in fact, there is an admission in their letter which I showed that since 2023, September or October 23, they could not utilize or use the property. That is also admitted. No, just show the judgments. But just one or two judgments for your lordship's kind consideration. Two 2019 tata was.
2019.
This is Lord 2019 volume 9 SCC page 94. This is Lord on creation of tenancy by the borrower. Lord, paragraph 24, if your lordships kindly come to.
Yes.
In our view, the objective of the Surface Act, coupled with the TP Act and the Rent Act, are required to be reconciled herein in the following manner. If a valid tenancy under law is in existence even prior to the creation of the mortgage, the tenant's possession cannot be disturbed by the secured creditor by taking possession of the property. The lease has to be determined in accordance with Section 111 of the TP Act for determination of leases, as the existing of prior existing lease inevitably affects the risk undertaken by the bank while providing the loan. It is expected the bank creditors to have conducted a standard due diligence in this regard. This is prior. Then 24.2. If a tenancy under law comes into existence after creation of a mortgage, but prior to issuance of notice under 13.2 of the Surface Act, it has to satisfy the condition of Section 65A of the TP Act. In any case, in any of the tenants claim that he is entitled to possession of the secured assets for a term of more than a year, it has to be supported by execution of a registered instrument. In the absence of a registered instrument, if the tenant relies on an unregistered instrument or an oral agreement accompanied by delivery, possession of the tenant is not entitled to possession of the secured assets for more than period of so and so. In the present case, bona fides of the tenants are highly doubtful, as there is no good sufficient evidence to establish the tenancy in the first place. The present case involves a tenant who allegedly entered into the oral agreement of tenancy before the mortgage deed was entered into between the borrower and the bank creditor. Additionally, it must be noted, etc. So, my lord, it says that phase, if there is an existing tenancy or lease as on the date of creation of the mortgage, that's different thing. There, my lord, the bank has taken a calculated risk of giving loan and taking the mortgage property with the lessee or the tenant. But if the tenancy comes into existence after creation of mortgage but before 13.2, then Lord, the procedure is that the Section 65A of the Transfer of Property Act needs to be followed. But if the tenancy is created post Lord 13.2, then Lord 13.3, 13.13 is a guiding factor. That has to be followed. Otherwise, there can't be a valid creation of tenancy. Now, Lord, to the same effect is the other judgment, 2019, volume 2, SCC 198. SCC, page 198. Lord, if your lordship's Lord kindly comes to about 6 lines from the bottom, there is thus paragraph 25. Paragraph 25, sorry.
Yes.
Your lordships may kindly take Lord 1, 2, 3, 4, 5, 6, 7, 8 lines from the bottom. The sentence starting with the word that there is thus a radical change in the borrower dealing with the secured assets from this stage. At the stage of a Section 13.2 notice, Section 13.13 interdicts the borrower from transferring the secured assets otherwise than in ordinary course of business without prior written consent of the secured creditor. But once a possession notice is given under Rule 8.1 or 8.2 by the secured creditor to the borrower cannot deal with the secured asset at all, as all further steps to realize the same are to be taken by the secured creditor under 2002 rules. Here, Lord, 2016 is post-Lord possession notice also.
Yes.
Because 2011, I have shown your lordships, Lord, 13.2 was 2011. 13.4 is also 2011. So, Lord, 13.13 had interdicted at that stage. And after that, the 2016, they say that this agreement was entered in. So, Lord, tenancy can't be a ground for giving the interim order, which the learned trial judge has completely misconstrued. But I also say that, Lord, the forum should have been, Lord, under section 17. The civil court shouldn't have exercised jurisdiction in entertaining this application under Order 39, Rule 1 and 2. 17 read with section 34 of the SURFACE Act. This is, Lord, my humble submission.
Yes, please.
Can I seek an extreme indulgence, my lord? Can I come back tomorrow?
Seventh, please do it today.
Wait. These points were not there, my lord, in the affidavit in opposition, or my lord, are good.
But we'll come back to it. We'll keep it as part of it. Third, learned senior counsel appearing for the appellant. Push up on the prayer of learned senior counsel appearing for the respondent.
After tomorrow, your lordship do not take up this matters.
No, tomorrow. Comma, the matter is adjourned for further hearing till tomorrow. Hard in part. প্রথমে তার আগে একদম আগে করে দাও। The appeal is admitted to be heard on the grounds taken in the memorandum of appeal and is taken up for hearing along with the connected application upon notice to both sides. কালকে পাঠারে অর্ডার ফটোর লিস্টে দিয়ে দেবেন, পাঠারে করে একদম অর্ডার ফটোর লিস্টের উপরে। হ্যাঁ, ট্রান্সপোর্ট অফ
Yes, I beg to appear on the actually this is the supplementary affidavit, and this is my affidavit of service.
What is the length of delay?
164 days delay.
Achha.
I don't know. 164 days delay, lordship. If your lordships kindly consider my supplementary affidavit, page 12, 14, 15, lordship.
Medical emergency agent mother, first member. But you have not pleaded anything. You have only annexed the document. You should have pleaded. The corresponding pleading should be there in the supplementary affidavit also. That this is the ailment and these are the documents. You have just annexed it anyway from the documents to us.
Lordship, page 12, 14.
This is regarding mother or you?
Lordship, this is my prescription, Lordship.
This is?
My prescription. There's
Your
applicant's prescriptions. Lordship.
What is the ailment? You have not stated anything. You have just annexed the living on us to decipher as to what.
Lordship,
cholesterol and all these things, personal, depressed. How are these sufficient grounds?
Lordship, starting from page 5, Lordship.
Neck pain radiating.
Lordship,
all of us have that. Particularly after hearing these sort of matters.
No, I don't know.
No, neck pain won't do.
Lordship, kindly
there is always a pain in the neck.
No, Lordship, page 5, Lordship, kindly consider.
Page 5, very well, yes. This is mother.
No,
you.
Shuman Bhaskar. And this is still continuing since since February onwards.
What about mother? You also claimed the element of
Lordship,
mother.
My mother, Lordship, is an aged lady, Lordship. But
that is the ailment.
No, Lordship.
She became well after hearing that you have to
Lordship,
file a
page
supplement.
26, 27, that is.
Despite affidavit of service filed to be kept on record.
On earlier occasion also, I filed.
Yes, we saw. Footstep despite service, none appears for the respondent. Footstep, the supplementary affidavit, comma, filed pursuant to our previous order, comma, by the appellant is kept on record. Footstep, from the documents annexed thereto, comma, we find sufficient number of medical documents having been annexed, which go on to corroborate the case made out in the condonation application as to the pressing ailments of the appellant during the relevant period, comma, which led to the delay in preparing the appeal. Full stop. Accordingly, comma, can 1 of 2025 is allowed, comma, thereby condoning the delay in preparing FMAT 501 of 2025. No arrest to cost. What is the appeal about?
Lordship, the appeal is preferred by the appellant is relating to the acted
Custody?
Lordship custody. The trial court
You are the
I'm the father.
father, right? So act date has been finally disposed of.
Finally disposed.
You are acted.
Your Lord.
Age of child and gender?
Lordship, female daughter, minor daughter.
Age?
Thousand 15.
মাইনর বললে হবে না তো 17 বছর আর 2 বছর No, the age of your child.
Lordship, 9th of July 2015 is the date of birth.
Calculate. You are very bad in calculating. 13 বছর 11 years.
11 years.
Daughters. So you took out the filed the acted case. Dismiss altogether.
Lordship.
No, instant application under section 12 is allowed. Oh, visitation. That was visitation.
Visitation.
Achha. So you were given visitation.
Lordship, initially the visitation right was granted by the trial court, Lordship, but that was not satisfactorily done by the opposite party, Lordship. I made several application before the trial court, Lordship, that was not considered, and finally the entire matter has been disposed of without considering that I am not getting a visit with my own
By
dog.
both applications. What is the impugned order dated?
Lordship, the
15th of February.
Fine.
Let us see. কি বলছেন সেটা visitation right কিছু দেওয়া উচিত ছিল মডিফাই করে দিয়েছে তাহলে সে তুমি তো না এলে কি করবে রাবিলি শেষ করে দিতে পারে সে ডেলিভারি ড্রাইভার স্ট্রিচের মতো very good videos come out video circulate which is in market custody cloud video এটা মা কমপ্লিট দেখে সব বাবা মারা গেল There is a scope of interference. 10 years with the mother, girl child, visitation at best.
Lordship, that is my prayer.
Was there an alternative prayer in your application for visitation?
Lordship, I made.
Where is your application? Let us see that. No, outright. So that we can consider, court can consider.
So only the visitation, right, Lordship?
See, we'll admit the appeal, we'll make it clear that we are admitting only on the aspect of visitation and we don't otherwise find any reason for interference. Because unless we put in that in our order, the mother will never come.
And if your Lordship's thinks fit that a special officer is required to be.
That we'll consider after hearing the mother.
Lordship.
If the mother still chooses not to come after service of Can 2, then we'll
Lordship.
pass her orders. The present appeal has been preferred against an order whereby the learned trial judge has dismissed the application for custody filed by the appellant father under section 25 of the Guardians and Wards Act 1890, primarily on the ground that the minor daughter of the parties within bracket, who is now about 11 years old, bracket closed, has been residing since her birth with her mother, and as such it would not be in the interest of the welfare of the child, which is the paramount consideration in custody matters, to grant custody to the appellant father. Full stop. In principle, upon perusal of the impugned order, we do not find any flaw in the same, and as such, there is no scope of interference insofar as custody is concerned. Full stop. However, we find that no arrangement of visitation right to the father vis-a-vis the child has been kept open in the impugned order. Full stop. Accordingly, we admit the appeal to be heard only on the question of grant of visitation rights to the appellant in respect of the minor daughter of the parties. Full stop. The appellant shall serve copies of the memorandum of appeal as well as Can 2 of 2025 on the respondent, along with a server copy of this order, indicating that the matter shall be listed under the same heading in the monthly list of May 2026. No, same heading hobe na. Matter will be listed in the monthly list of May 2026 under the heading application, with the understanding that the appeal along with the application shall be taken up for hearing on the limited question as formulated above. Full stop. It is made clear that such notice shall be deemed to be a notice of the appeal as well on the respondent. Full stop. An affidavit of service to that effect shall be filed on the next occasion when the matter is called on for hearing.
Lordship, subject to conditions, correction, Lordship, as per direction of your Lordships, I have already served memorandum of appeal along with all applications.
Yes, we understand, but that was not specific, because otherwise you have to put in requisites. Notice of appeal has to go to the respondent. That's why we incorporate. That's why we ask you to serve a copy of this order also, because we treat this to be a notice of appeal. We are making an exception because it's a custody matter. Neither you, nor the mother, nor the child deserves long pendency of appeal in this court.
Grateful to Lordship.
One correction we are making. We have said since birth, since his her early childhood. Since her early childhood was with the mother. Next.
Great.
Number 20.
There are two appeals. I am appealing on behalf of the respondent in respect of my senior sir.
Respondent number 1.
Respondent number 1.
You are appealing for all for respondent number 1. Who is not represented, or 2 are there only. You are supporting whom, him or him? Yes. Yes, Mr. Banerjee.
This was a suit for declaration, partition, and injunction. Declaration to the effect of declaration of my share in the suit property, partition of the suit property, and injunction. The my plaint, proceeds on a basis that the suit property was a trust property till a particular point of time when, according to the deed of trust, the trust got dissolved and the property, stood vested in, the plaintiffs in 50% share and in the defendants, for the balance share. So, I asked for partition. The suit property was valued, court fees were paid, everything was done. My learned friend filed, a 711 application. Saying that, the suit has been, the reliefs claimed in the suit have been, undervalued, and, I have suppressed some fact. The facts which he alleged, I have suppressed in the plaint, the plaint makes no whisper about those facts, is that, there was a previous suit for partition filed, before this honorable court, wherein, an arbitrator was appointed. The arbitrator proceeded, with the arbitration proceeding past an award beyond time, After the award being passed, my lord, the Honorable Court was approached for extension of, my lord, the mandate of the arbitrator. Then, the Honorable Court said, my lord, nothing doing since, my lord, the arbitrator has been appointed. We are not extending the time. So, my lord, the award ultimately had, my lord, no effect. And, my lord, the suit stood dismissed for default also. These are the facts. These were the facts, my lord, which are not, my lord, according to them, disclosed in the plaint. So, my lord, on the ground of the suppression of material facts and, my lord, on the ground of valuation of, my lord, the reliefs claim in the suit, they filed 711. My lord, I filed an application, my lord, for appointment of receiver because, my lord, the property was, my lord, being disseminated at their hands. My lord, the property is a huge property. When the suit was filed, my lord, before this honorable court, the property was still under the trust. My lord, that was not, my lord, indicated by them in their demerit application. Be that as it may, my lord, the suit property has almost, my lord, 50 rooms. So, my lord, if I am entitled to, my lord, 50% of it, my lord, 25 rooms should come, my lord, to my allocation. I am in occupation as of now, my lord, of 2-3 rooms, which, my lord, I have pleaded in the plaint. So, my lord, for getting, my lord, occupation, getting back occupation position of the rest of the portion, my lord, the suit was filed, my lord, asking for injunction as well. My lord, what the learned trial court did, my lord, the learned trial judge, my lord, took up, my lord, my application for appointment of receiver as well as, my lord, my learned friend's application for, my lord, rejection of the plaint. My lord, rejected my application, dismissed my application for appointment of receiver on the ground of valuation, depending upon, my lord, an e-assessment slip. Without, my lord, considering that, my lord, under section 6 of the West Bengal Court Fees Act, my lord, when I, my lord, sue someone for partition and, my lord, asks for, my lord, possession of, my lord, the rest of the portion I'm entitled to, it's, my lord, the share, value of the share which I'm claiming back should be, my lord, the value of the suit. And, my lord, no exercise was undertaken and not, my lord, the valuation of the entire property. And secondly, my lord, no exercise was undertaken under section 11, 12, 13. My lord, his application under Order 7, Rule 11 was also rejected. And, my lord, the plaint was directed to be returned for, my lord, being presented before a proper forum. My lord, these are, my lord, the facts of the case.
So his ground of suppression was virtually not accepted because
not in that sense. My lord,
if it was accepted, then it would be rejected outright.
Yes. And, my lord, it was a 711 application.
Undervaluation was accepted.
Yes.
Especially accepted.
And, my lord, this allegation of suppression was also accepted.
Achha.
Was also accepted. But, my lord, in a 711 application, my lord, I doubt, my lord, how far, my lord, the court can act on, my lord, alleged suppression of facts.
And what is the other appeal about? Which was
my lord, my learned friend has filed an appeal because his 711 application was rejected.
Oh.
Because my 711 was rejected, my lord,
no appeal lies.
My lord, no appeal lies.
My lord, that, my lord, the 7 rule 11, my lord, was rejected, my lord. That is why, my lord, we have preferred the appeal. My lord, I know, my lord, the appeal doesn't lie. My lord, if my lord will kindly come to the order, my lord. We have also filed Order 7 Rule 11. We have filed Order 7 Rule 11 application.
You treated to be an order under 710.
Yes.
And that's why you preferred the
That
appeal.
is why, we have preferred the appeal. Because, my lord, the ground, the order was the impugn
Then
order.
711 you are not challenging. 711 rejection.
The impugn order I am challenging.
You can only then, you have to be restricted in the appeal only to that return of the plaint. Should not have been returned.
Yes.
But you cannot claim rejection of the plaint now.
Lord, we have only challenged the impugn order to some extent. That is our.
So therefore, even if you win this appeal, then the return of plaint will be set aside. But even if you get that relief, the plaint won't be rejected.
Lord, he is then with me.
I don't know.
Lord, the appeal was preferred, not on my part. The advice of Mr. Lakmani, my lord, he is leading me in this matter. But, my lord, Mr. Lakmani has filed the appeal on advice, but, my lord, he is
will carve out a provision of appeal against Mr. Lakmani.
No, my lord. My lord, he is leading me
against him.
He is leading me in this matter, my lord.
That's why. So this was his brainchild. Never expose your senior or junior for that matter. All the more so.
But this order is
even if you win this appeal, they win. You win your appeal, they win. the return of plaint will be set aside.
But
The trial court has to hear it.
But
And
the-
711 rejection, you are not challenging.
This order lies civil revisional application.
Yes. 115. This is a pure 115 case. Not
Because order
227.
711 was rejected, not allowed.
Yes. If it was allowed in your favor, you would have finally decided this.
That tantamounts to a deemed degree.
No, that tantamounts to a
If
final order
order
under
711
115.
was allowed.
Anyway,
May I take your lordship?
should we? You are enjoying an interim order. There is no scope of interim order because your
Because
it
the
has
claim
been
has been
returned.
directed to be presented before an appropriate court. That
Like to
court
wait
can-
for Mr. Lakmani.
He's leading me. He's told me that he's in the court number 33 and the matter is going on. He told me to pray for a short passover only in respect of the our appeal is concerned.
And do we want a receiver also to be appointed because the
And-
property is getting disseminated.
And in respect of my learned senior friend receiver application is concerned, we will file a opposition.
Till then, there will be a receiver and then we file opposition.
Well, I will satisfy to your lordship in respect of
We'll
the
appoint you as a receiver and till your filing of opposition.
Affidavits were exchanged before the learned trial court. We have annexed everything.
Then we hear you. Yes, please continue. But we are doubtful as to the outcome of the appeal, their appeal. But if we pass over the matter, we don't know whether we'll be able to.
if my lord will kindly fix at 2 p.m. It will be easier.
We can come back tomorrow, subject to, of course.
Tomorrow we don't know if. Yes, we will sit, but tomorrow is the appeal hearing day. No, tomorrow is Wednesday. So tomorrow second half only second half.
May it not be given some preference in that case. Since Mr. Lakmani is appearing, I do not stand in the way of the prayer for that.
If my lord will kindly fix it at 2 p.m., we will do the matter.
Maybe necessary. We are passing it over. Passing it over. The understanding is that after recess, at the first possible opportunity, if you are continuing with some matter, then that matter will go on. Then
Three
after
of us are would remain occupied in a fixed matter. Three of us.
together or
Together.
separate. In any event, we cannot continue with this because we have only some minutes left.
The second half tomorrow, subject to my lord's kind approval.
We'll keep it tomorrow then. Whose prayer?
Mr. Komoka need some precedence, want some precedence in the matter.
কিরম পজিশন থাকছে আগে কতগুলো অর্ডার প্যাটার্ন তো পাঠাত বলে তবে দ্বিতীয় দিন তাহলে কোনো ম্যাটার হবে না এটা দ্বিতীয় দিন এখন but this will be the second there is a fixed matter at the top tomorrow. This will be the second one. On the prayer of counsel, the matter is adjourned for the day. Prayer of counsel because we will be engaged in the second half. We won't be able to continue.
Grateful minutes.
I'm great.
Tell Mr. Lakmani there what is your opinion and my opinion. And my learned brother has not yet expressed his opinion, so he will when Mr. Lakmani comes.
I'm grateful.
But I appeal for the
Yes, Mr. Rai.
But I appeal for the appellant. But this is an appeal.
My lord, I'm led by Mr. Roy.
But, this is an appeal.
You let me Mr. Inoil Rai.
Mr. Roy, my lord.
My lord,
Yes.
My-
Yes.
my lord, Mr. Tohit Khan is appearing for opposite party number 1 and 2. He is unable to attend the court due to some health issues.
This has been admitted, Mr. Rai.
No, my lord, what happened is, my lord, this was heard.
My
My lord, it was heard at the order 41 stage. And my lord, the respondents were also represented. And my lord, hearing was concluded. And it was fixed for orders on a particular day.
By us.
Thereafter, no. By a coordinate bench, long back, my lord.
In
It's a
2020.
2019 appeal.
Both of them are not.
And in
Yes.
2020,
So that's the reason why, my lord, it was in limbo and ultimately it has been assigned to your lordship.
What is the appeal against, Mr.
My
Rai?
lord, it's against an order of temporary injunction, refusal to pass an order of temporary injunction.
Are you enjoying any interim protection?
No, my lord, that's the reason my lord,
What is the nature of the injunction you are seeking?
my lord, I am seeking an injunction.
But then we'll have to consider his prayer.
Yes,
Otherwise,
my lord,
this
restrain
injunction has been
them.
refused. Yes.
but not to change the nature and character. And second is they are restricting our free ingress and egress through a common passage. That
Why was it refused, Mr. Rai? Injunction application itself was dismissed.
Yes. Yes.
Achha, why was
Because,
it?
It's a suit for specific performance for enforcement of an agreement for sale, which is an oral agreement for sale. So now, the learned judge came to the finding that an oral agreement for sale is not valid in law because no stamp duty has been paid on that. Then, second issue on which he refused is that I cannot seek any injunction so far as the common passage is concerned because it is not a part of the suit property. That's one, because I have identified the land. But in my respectful submission, that is not correct because I have included all the easement rights and other things in that. These are the two main points on which he has refused. Secondly, he says that there is not enough evidence to show that there was an oral agreement. According to us also, there are letters which they have received. They have not replied to those letters contemporaneously. It is only after filing the suit that they have denied that no, there is no oral agreement and so on. And from the other circumstances,
Concluded contract, is there any consensus ad item? I mean, from the letters. If that be not so, then
no letters.
Some prima facie.
The consensus, in my respectful submission, it comes from the fact that they received the letters. They have accepted in their written objection that we have received the letters, but they have not replied to it.
Show us your best letter, Mr. Rai.
Okay, and the other fact on which I'll show your lordship the letter just now.
Yes, yes. So one is oral agreement
is invalid due to non-payment of stamp duty. That's one. My answer to that in short is that stamp duty applies to instruments. It is only when there is an instrument, stamp duty has to be paid on that. Under section 10 of the Contract Act, an oral agreement is valid. That's my submission before your lordship. The second point is that the common passage is not a part of the suit property. That your lordship will see the schedule, that all my easementary rights are there. I have also identified where is the common passage and so on. And the third point is that he did not find sufficient evidence to come to the conclusion that yes, prima facie there is an oral agreement.
Sir, Rai, let us start with the shortest point. Let us see the plain schedule on that.
And see the plain schedule
regarding the common passage.
Only take can 1, the first application. That's the original application. Yes. It is at page 322.
We may throw this at you if you are not sufficiently satisfied of your case. Because this is a fit instrument of injury. Dark numbers, yes, all that we can person. Together with all easement and
quasi-easement rights, there too, together with all rights, liberties, privileges, and so on. And your lordship will see that on the south and on the east is button and bounded by the common passage.
But you are claiming easement right. You have to claim whatever rights you claim in the suit on the suit property.
Yes.
If that is not included in the suit property, then.
But kindly see what is my prayer. Kindly,
prayer as well as the body of the print also will look into your,
yes,
not merely the schedule.
Kindly see page 320, prayer F, not to change the nature and character. Second is not to make any construction and restricting free ingress and egress of from the common passage, entrance on National Highway 6 to the suit property.
So very well. You have put this dominant heritage in the scheduled property, but the sergeant heritage.
The reason for filing the suit is that the defendant number 1 entered into an agreement, a development agreement in respect of the suit property with the defendant number 2 and put up a board there that they would start construction. That is when we filed the suit, that you have an agreement with us and you cannot enter into an agreement with somebody.
Do they admit that it is a passage?
Yes.
Not common, but passage.
Passage they admit, because there is no other entry even to his property. He has to go through that.
And in the body of the plaint, where have you pleaded that they have, let us just see, that they're preventing your ingress and egress? ফিক্স করিনি, কালকে ফিক্স করব।
Kindly see, my lord, paragraph 24 onwards, your lordship will kindly see.
25 is very categorical.
25 is there also. Lord, I have the the defendant number 1 and the pro forma defendant number 6 to 32. They are all members of one family, the Pal family. Now, my lord, they have about 24 acres of land in Domjur. I entered into agreements with all of them to buy the entire property. I have purchased everything else from everybody else. With him, I had an oral agreement. He has 3.86 acres in that property, both undivided and divided. Undivided, he has already sold to me. The divided part, this particular part of the property was to be sold to me on completion of 2 or 3 conditions. Those conditions I have fulfilled. It is only at that stage when he refused and made an agreement with somebody else to do that. So my submission would be, my lord, that I can show at least 30-40 deeds that all property in and around that, including all his family members, everybody has sold it, and he himself has sold the entire undivided portion. In part of divided portion also.
Sir, I will continue with this matter. We'll start from the oral agreement. You need not probably satisfy us, but no proof of oral agreement. Those correspondence we will see after. You please get prepared in the matter, because we have to admit the appeal and at least grant an identity order, because otherwise their ingress and egress is concerned. We cannot grant you adjournment. Just get prepared in the matter. Take instruction from Mr. Khan. What you will say? Yes.
My lord, very request, my lord, the very next matter, Mr. Mukherjee is on the other side. My lord, I have a medical appointment, my lord, for which I need to leave.
23.
My lord, 23. My lord, tomorrow or in day.
23 একটা বোর্ডে দেখিয়ে দিন একবার।
23.
You are for the respondent.
For the respondent.
I appear
for
The matter is adjourned for the day on the prayer of the on the prayer of the respondent.
I am so grateful, my lord.
নামগুলো Mr. Mukherjee, please ask your.
Yes, my lord.
Give your name.
The Contract Act.
Your Lordship,
Yes.
before the list
In
is.
the midst of a matter, ma'am. Yes. Yes. please.
Page number 167 is my first letter.
Yes.
And my lord, after that, your lordship will find two reminders, one at page 170, another at page 172.
They did not reply to this.
No. In the written objection, they have denied the contents of this letter, but contemporaneously, no denial. And in the written objection, they never said that they did not receive these letters. They have denied the contents, but the receipt of these letters are admitted.
They have come now.
Lord, I am handicapped, absolutely handicapped. But I cannot answer to any of the queries for which
Why?
they fall. Because this has happened at one point of my lord, we'll find our names there. This matter was made CAV. Thereafter,
Yes,
we
you
have
heard that.
returned the brief. We are now briefless entirely. I only received a copy of application shown by him, which was filed and mentioned, but the
Why did you return the brief? It was made CAV only.
CAV, but we returned the briefs to the client. We need
Before
to
the judgment is delivered. You feared that you would lose and there will be a backlash.
But I remember one argument was advanced. Probably, we were led by just.
Let him complete. Yes. Yes. Yes, Mr. Yes. So these are the letters.
These are the letters.
This takes care of the oral agreement part.
Yes.
There
But
was
we have also, if your lordship takes page 65, but that is the list of the deeds which we have executed with the defendant number 1 in respect of part of this property, leaving out the scheduled property. Page 65, kindly see, there are 5 deeds. My lord, all these deeds have been submitted by way of Firisti before the learned court below. Court has seen these documents. The court comes to the finding that nowhere have you written that these deeds are being executed pursuant to an oral agreement.
There is a point in that. The oral agreement, this does not per se prove the oral agreement.
What I am trying to impress upon your lordships is this, my lord, that there is a series of transactions. I am buying the entire property. I am showing
other co-owners.
Other co-owners and him as well.
He also sold another part of the.
All these 5 deeds, he has sold part of his divided and undivided property. Other co-owners have sold their entire property.
So only a portion.
Only this portion remains. So from this is my circumstantial evidence, which shows that I have purchased the entire property. Only this part is left. And he says, well, I cannot find anywhere it is written that there is an oral agreement.
130টা একবার দেখান ওই অন্য কোয়ার্নারদের যে টিটগুলো সেগুলো পুরো লিস্ট আছে
But page 130, your lordship will find the list of all the deeds with all the other co-owners. Page 130 to 135. I have given a list of 46 deeds.
যেটা আপনি বার করেছেন। Yes.
So now he says, a part of the order your lordship will see,
yes,
that I have not said, I have said the date of the oral agreement. But where, who were the parties, who negotiated with whom, all these things are not given. Now, but these will come out at the trial stage. Today, my lord, to seek an injunction, I have to prima facie satisfy the court as to the existence. My lord, my humble submission is that these letters, all these deeds which show that I have purchased the entire property excepting for the suit property, everything shows that there were transactions both with the defendant, with the other pro forma defendants, and that is sufficient to at least give me an injunction to the extent that he should not change the nature and character of the property. And my lord, it's an admitted position that there is only one common passage going into the property, the entire property. Now I am owner of rest of the property. He is owner of a part of the property.
Sir, have you pleaded in your plaint that this is the only passage or something like
Yes,
that?
my lord,
Easement of
yes,
necessity.
yes. Your lordship will, my lord,
That element also.
I have read. Yes, my lord, the plaint. It starts from 296. Just indicate the clear. Yes, well, kindly see page 305, paragraph 3. The said property is situated on National Highway 6 and the entrance of the said property is through a private common passage of 30 feet width from the National Highway 6. This is further borne out from the sketch map as annexure B here in above.
Let us see the input order once. Yes.
Starts at page 422.
You can refer to the internal pages.
Yes.
Seeing from the memo. The court regarding that stamp duty court relied on.
Yes, that your lordship
Law of
filed
the
in
state.
internal page 7.
Yes, exactly.
Here in the instant case, the defendant number 1 has raised a question of law as an impediment to oral agreement referring to Article 5D and Article 23 of the Indian Stamp Act, white stamp duty on instruments in West Bengal. That was my point, Malad. If there is an instrument, that will certainly, Malad, attract stamp duty. But where there is no instrument, the payment of stamp duty does not arise. And if your lordship sees section 10 of the Contract Act, oral agreement is valid and there is no law which prevents an oral agreement for sale of property. Okay. 2009 SCC.
Right. You also relied on 2009
Yes.
too.
Well, kindly have a look at this.
Court says that yes, it holds that proposition, but this law of the state.
But it's not a bar. That is what the court itself says. Kindly see paragraph 17. Section 10 of the Act provides that all agreements are contracts if they are made with free consent and the parties competent to contract for a lawful consideration and with a lawful object, and are not expressly declared to be void under the provisions of the Contract Act. The proviso to section 10 of the Act makes it clear that the section will not apply to contracts which are required to be made in writing or in presence of witnesses or any law relating to registration of documents. Our attention has not been drawn to any law applicable in Bihar at the relevant time, which
Court
requires.
says that no, there is a law that he refers to apparently the stamp duty, the Stamp Act.
No, but that is not a bar. But if there is a.
Does not require an oral agreement to be in writing.
Yes.
Once it is in writing, stamp.
Yes. That is my point. And What he has said, you have not said this, you have not said that, I have not got it from this. But kindly consider this, what more do I show? I say that I am purchasing an entire big plot of land.
Yes.
Everybody else, it involves about 30 family members. Everybody has sold their land to me. The defendant number one himself has sold part of his land to me, both divided and undivided. It is only in the last portion, at that time he is refusing. I give him a letter saying that there is an agreement, please adhere to it. I give him reminders, he accepts those letters, does not dispute it at the relevant point of time, and makes an agreement with a third party and starts construction. I immediately come to court seeking an injunction. And I humbly submit that from the circumstantial evidence which I have produced with the plaint and the injunction application, at least to this extent, that they should not change the nature and character of. And so far as the common passage, I have also, there is a pleading, it is there in the schedule, it's there in the prayer.
Yes, Mr. Charity, you cannot help us.
Only I said, I remember this point was argued whether oral agreement after the SMST, and Garware, whether it can be enforced, because there is no place where it can be stamped. Now, that was one of the argument advanced, and made CAV. But factually, I cannot assist because I do not have the copy, If I can lend a copy from him, I can come back any day. One day.
Interim order, keep the application, fix the application in the monthly supplement.
I don't know, there if the construction is complete, because it has happened. This is not today. This interim order refused, since long. This application has been filed at least, in 2021. Now, it is coming up after 3 years. The entire scenario might have changed there.
Let there be a status quo as on date. Whatever the scenario, let there be a status quo as on date.
They seek an injunction restraining from disturbing their common passage.
Yes. To that, I'm sure.
Since it was already sold to a third party, construction has come up, properties have been sold. If this has happened, then this has to be also be brought to the notice of court.
Bring it to the notice, we will direct to file opposition. As on today, their immigration egress cannot.
But kindly give them 1 day time,
No, we have heard it at length.
I understand, Only predicament, today I am not in a position. I am very candid in the first stage.
Several arguable questions having been raised, we admit the appeal to be heard on the grounds taken in the memorandum of appeal. Who's up next, para? Learned counsel having instruction to appear for the plaintiff stroke respondent. Respondent number 1 or what? Or only respondent?
One is the
sorry, defendants. You are the plaintiff, sir.
Respondent number 1 is the primary defendant.
1 and 2.
2 is
1 and 2, and 3, 4, and
party.
5 are the persons to whom it has been sold.
Counsel appearing
6
for
to
the
32 are the other owners.
Learned counsel appearing for the respondent numbers 1 and 2 submits that he is handicapped since the matter was previously heard at length by a different coordinate bench, which reserved the matter for judgment, but subsequently, since none of the judges comprising the said bench are available, the matter has come up before this bench. First up, it is submitted that learned counsel for the defendants to respondent numbers 1 and 2 has returned the papers to his clients and requests some time to respond to the arguments. So next para, however, in view of the urgency pleaded, we take up the application for the limited purpose of considering the grant of ad interim orders. So next para, the matter arises from a suit for specific performance and permanent injunction filed by the plaintiff stroke appellant, in connection with which an application for temporary and ad interim injunction was filed. So by the impugned order, the learned trial judge dismissed the temporary injunction application on contest on several grounds. So the primary grounds on which such refusal was made are niche Roman 1, that there could not be any specific performance of an oral agreement in view of such agreement not being valid, being not accompanied by the appropriate stamp duty as required in law, semicolon, Roman 2 niche, that on facts, comma, there is no proof of any oral agreement having been entered into between the parties, semicolon, Roman 3, that the common passage on which the injunction, temporary injunction has been sought for is not a part of the suit property as described in the schedule of the plaint, and Roman 4, that there is no urgency in view of the long lapse of time between the cause of action and the filing of the suit, and in the absence of the plaintiff stroke appellant pinpointing as to who was the representative of the defendant's respondents who was dealing in the matter. So next para. Insofar as the first ground is concerned, comma, we are unable to accept the same, since, as rightly argued by learned senior counsel appearing for the appellant, comma, Section 10 of the Indian Contract Act envisages even oral agreements to form a contract within the contemplation of the said statute. For sub next para, the premise of the learned trial judge that the said proposition, which was upheld in Aloka Bose versus Paramatma Devi and others, reported at 2009 to SCC 582, was distinguishable in view of the law prevalent in the state of West Bengal, which mandates the mandates an agreement to be in writing and stamped properly, comma, was not brought to the notice of the Honorable Supreme Court. However, comma, such line of distinction is prima facie misconceived, comma, since there is no statute in West Bengal which mandates an agreement to sell to be in writing. Full stop. The Stamp Act as well as the Registration Act, comma, prevalent in West Bengal only pertain to written instruments. Full stop. Therefore, comma, only in the event an agreement is reduced to writing, comma, which contemplates a transfer in presentee or in future, comma, is the same required to be stamped. Full stop. Next para. However, comma, fundamentally, comma, there is no bar to a contract not being in writing and merely being verbal, comma, in which case there is no question of applicability of the Stamp Act or the Registration Act. Full stop. Next para. Thus, comma, per se, there is no bar to an oral agreement. There is no bar to a suit for specific performance being filed in respect of an oral agreement. Full stop. Next para. With regard to the second ground of refusal by the learned trial judge, comma, we find from the several correspondence annexed to the plaint and the temporary injunction application in the trial court that, comma, specifically referring to the oral agreement between the parties and asserting part performance of the same, comma, the plaintiff stroke appellant had written to the defendant numbers 1 and 2 stroke defendant stroke respondent numbers 1 and 2. Full stop. However, comma, there was no reply from the end of the said defendants. Full stop. In the written objection to the temporary injunction application, comma, although the contents thereof have been denied, comma, the receipt of such communications has not been denied. Full stop. Thus, comma, there is no contemporaneous objection of the defendant numbers 1 and 2 to the assertion by the plaintiff stroke appellant as to an oral agreement for transfer of the property being in existence. So next para, moreover, comma, by way of prima facie collateral evidence, comma, several purchase deeds have been produced by the appellant, comma, executed by the defendant numbers 1 and 2 as well as other co-sharers of the property, comma, pertaining to surrounding properties which allegedly emanate from the self-same oral agreement. Full stop. Next para. Although such documents do not comprise of direct proof of the agreement, comma, nonetheless, comma, for the limited purpose of ascertaining whether there is a triable issue fit for grant of injunction, sufficient materials were placed by the plaintiff stroke appellant before the trial court at the stage of hearing of the injunction application. Thus, there is sufficient prima facie proof of there being consensus ad idem culminating in an oral agreement between the parties for sale of the subject property. So next para, the next issue which arises is whether the common passage not being specifically a part of the suit schedule property, the injunction could not be granted. From a composite reading of the various paragraphs of the plaint, we find that the plaintiff stroke appellant has categorically asserted that
296 it starts. 305.
Right.
Five.
Asserted in paragraph number 3 of the plaint that the suit property is situated on the National Highway 6 and the entrance of the said property is through a private common passage of 30 feet width from National Highway 6, which is also borne out from a sketch map annexed as Annexure B to the plaint. Next para. In the schedule of the plaint as well, the suit property is described to include all easement and quasi-easement rights, together with all rights, liberties, privileges, along with right to free ingress and egress. Also, in relief small g within bracket in the plaint, a specific decree of permanent injunction has been sought restraining the defendant numbers 1 and 2 and or their main agents or servants from changing the nature and character of the suit property, making any construction thereon, and more importantly, restricting free ingress and egress of the plaintiff from the common entrance on National Highway 6 to the suit property, as also the plots of land owned by the plaintiff. Next para. Thus, since the dominant heritage itself is a part of the scheduled property in the suit, and the right of ingress and egress over the servient servient heritage has been categorically asserted in the plaint and the temporary injunction application, there was no bar for the learned trial judge to consider the grant of injunction with regard to ingress and egress to the suit property on such count. Next para. Hence, the said ground of refusal of temporary injunction cannot also be accepted. Next para. Insofar as the question of urgency is concerned, the nature of injunction sought is a continuing cause of action, and mere absence of any name of the representative of the defendants who was dealing in the matter does not vitiate the plaint case prima facie as to there being an agreement, oral agreement between the parties, more so in view of the discussions above relating to the other corresponding documents which have been produced along with the plaint and the temporary injunction application. Next para. Thus, we find a sufficient case of sufficient prima facie case for injunction having been made out. Next para. Although learned counsel appearing on behalf of the respondent numbers 1 and 2 submits that he is not apprised as to whether any further construction has taken place on the subject passage, fact remains that it transpires from the materials on record that the plaintiff stroke appellant has also claimed an easement of necessity going hand in hand with the prayer for specific performance, and the location of the passage is such that it leads into the conglomerate of surrounding properties around the suit premises as well. Next para. Be that as it may, in view of the above, discussions, we are of the opinion that a sufficient prima facie case has not only been made out, but a case of urgency as well as balance of convenience and inconvenience being in favor of grant of injunction has also been made out. In the event further constructions are made or the ingress and egress of the plaintiff to the suit property is restricted, the same may lead to irreparable injury to the plaintiff stroke appellant. Accordingly, the respondent numbers 1 and 2 and or their men and agents are restrained by an order of injunction from making any construction on the common passage, as described in paragraph number 3 of the plaint, leading to the suit property, as on date, till disposal of the injunction application. Next para, the respondent numbers 1 and 2 and their men and agents are also restrained from creating any hindrance to the ingress and egress of the plaintiff stroke appellant in respect of the suit property over the common passage, also till disposal of the injunction application. The respondent numbers 1 and 2, who are the primary contesting respondents, shall file their written affidavit in opposition to the can 1 of 2019 within bracket old number can 12383 of 2019 within 3 weeks.
No, 2 weeks.
Within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing in the monthly list of May 2026.
Only thing, my lord, kindly direct them to serve a copy, my lord.
Sir, please ensure that give extra copies. Yes. Great. And you pay for the Xerox. Your client, your responsibility.
Well, in the other cans, which we had filed from time to time, also we filed the affidavit of service.
After line, affidavits of service filed today be kept on it.
No, online may be added, my lord, on completion of that period, liberty to mention for hearing. Kindly.
You will take undue advantage of that, or due advantage of that, which is undue to us. Yes. Next.
I'm ready.
Thank you.
Obligement.
Thank you. 24.
Of the plaintiff appellant,
Yes.
your lordship would kindly take up can 3 of 2026.
What about the affidavit of service? Mr.
Yes,
Rana?
This is the affidavit of service.
They have received.
Oh, it is sorry.
They have received.
Yes, yes, they have received.
On behalf of the respondents.
Your lordship,
The respondent.
can 3,
You are appearing for all the respondents.
No matter. Few of the respondents.
Few of them is which?
all of them have been served.
All of them have served. Very.
Out of,
42 respondents.
out of
Suit for
42
partition.
appearing on behalf of
Partition
18
suit.
Your lordship, yes, man. Kindly takes can 3 once. My lord, there are twofold prayers. One is appointment of next friend. My lord, that, my lord, I will not be pressing because the person concerned, the co-appellant, has become major. But the other prayer, my lord, substitution has to be carried out. Anikesh Das, was the minor. He's already on record. Arjo Das and Mouli Das need to be substituted.
Who has died?
The other co-appellant,
With us.
Bobby Das.
She was the mother.
She was the mother. Mother and younger son had filed the suit and the appeal.
Substitution has been filed within.
Yes, yes, within time. It's within time.
So you are allowing the substitution and.
No, no, 1 minute.
Yes. Yes.
Hello, if brother wants to be substituted in place of mother, then the brother and the sister has to be in the suit as well as in the appeal.
It's their suit.
Their suit.
Lord, I am carrying out substitution in this appeal, my lord.
There has to be.
What is the can number?
Can 3.
Can 3 is a substitution.
Yes, can 3 is the substitution.
Why do you say appropriate orders?
Because, my lord, at that point of time, my lord, we sought another prayer that was for appointment of next friend.
Both prayers are included here.
Yes, both the prayers are included.
A brother can be a next friend. I'm putting a question onto my.
My lord, now that prayer I am not pressing because he has attained majority.
Then the matter will be dismissed for the non-joinder of party.
Huh?
Necessary party. As because the brother, they are stating the brother.
Their brother is not in the
Their
suit.
brother is the son of the mother who has died. Brother and sister you are wanting to add?
Yes, my lord. They are not in the suit. They have to be
Need not be. This should percolate down also, but this is not a final appeal.
My lord, one thing,
What
my
the proposed substitute heirs?
But proposed substitution heirs are Arjo Das and Mowli Das.
Where have you named them?
Kindly takes paragraph 2.
Yes, you've given a chart.
Yes.
Yes, my lord. The chart has been given, but their father name has not been incorporated.
Father is alive?
Yes, father is alive.
Their
Father,
father, my lord. Who is the father of the Arjo Das and Mowli Das?
But I tell you, Lordship, my lord. Bobby Das, who was the mother, she had
your father is dead.
Who is the father of Bobby Das and
Manish Das,
Arjo
son
Das?
of late Mohanlal Das.
Yes.
Her husband is not alive.
Yes, husband is not alive.
The sons have been implicated, son and daughter.
Arjo Das is whether Arjo Das and Mowli Das are the sons of.
No, they are not the sons. One is the son, one is the daughter.
One is the son and one is the daughter of.
Of Bobby Das.
Yes.
Father is the property of Mohanlal Das, if I am not wrong, my lord. Mohanlal Das died after the suit has been filed by Anikesh Das and Bobby Das. Property is Mohanlal Das. Suit has been filed by Anikesh Das, son of Mohanlal Das.
No, what he means to say is probably that if Mohanlal Das died prior to filing of the suit,
yes,
then his rights devolved not only on you and your mother, but also on Arjo and Mowli.
Yes, but here is one thing, my lord. Arjo and Mowli are sons of another father who has already died. Bobby Das had contracted 2 marriages. First marriage, both of them whom I seek to substitute, they are from the first marriage. Second marriage, I am the son. And that I have explained that in my application.
Then they did not get the property through Mohanlal Das.
Yes. After the death.
They has not been explained in the Can 3.
My lord would kindly take my Can application.
Can 3. There has to be stated. There has to be proper avertments. When the marriage has been communalized between the appellant, between Mohanlal Das with appellant number 2.
My lord would kindly take my annexure X. That my lord will find death certificate of both the fathers, Mohanlal Das and Milan Das.
Which page? Milan Das?
Kindly takes.
Yes, 15 is Milan Das.
Milan Das is the
certificate.
Our certificate of course. And I have said that in paragraph 4 that the right to sue survives upon them.
There has to be proper statement, my lord. There has to be proper avertments. Even if in the tabular form they have not highlighted, Arya Das is the son of Milan Das, as well as Mowli Das is the daughter of Milan Das. Even if in the cost title of the Can 3, page 8, they have not stated so. Page 8 of the Can 3.
We're recording your submission, sir. Can 3 of 2026 was originally filed with for 2 reliefs hyphen leave for the appellant number 1 Anikesh Das, comma, then a minor, comma, to be represented by his next friend, and for substitution of the heirs and legal representatives of Bobby Das, B-O-B-Y, Das, comma, the appellant number 2, comma, on her demise. To sub next para, learned counsel appearing for the appellant submits that in the view of Anikesh Das having since attained majority, comma, the appellant does not press the prayer for being represented by an next friend. To sub, however, comma, it is submitted that on the demise of Bobby Das, comma, she left behind as her heirs not only Anikesh Das, comma, from one of her husbands, Mohanlal Das, late Mohanlal Das, but also one Arjo, Arjya Das and Mouli Das, comma, who are her progeny through one Mihir Das, comma, one Milan Kumar Das, comma, who she had married. He was the previous marriage.
Yes, previous marriage.
Milan was the previous. Whom she had married prior to getting into matrimonial bond with the father of the appellant number 1. To sub next para, it has been averred in the application that both are major and sui juris. Sub next para, learned counsel appearing for which respondents?
Respondent number 7, 19, 20, 21, 22, 23, 24, up to 30.
For some of the respondents who are contesting the matter,
18 respondents,
comma, contains that the application is not maintainable on several counts. First, comma, the names of Arjodas and Maulidas, names of Arjodas and Maulidas were not impleaded as parties in the main suit from which the present miscellaneous appeal arises, and as such, comma, for the first time they cannot be impleaded here. Secondly, comma, it is argued that Arjodas and Maulidas, comma, if they claim through Bobby Das, comma, who in turn claims through her husband late Mohanlal Das, comma, were necessary parties to the suit as well as the appeal from its inception. In the absence of such impleadment till now, comma, such lacuna cannot be permitted to be filled up by substituting them as parties to the appeal, comma, in particular where they have not been impleaded in this suit. Next para. Thirdly, comma, it is contended by the contesting respondents that in the application for substitution, comma, it has nowhere been mentioned clearly as to Arjodas and Maulidas being the children of late Bobby Das through a different husband than Mohanlal Das. Next para. In the absence of such specific averment, comma, it should be construed that Arjo and Mouli also claim through Mohanlal Das, comma, the admitted that the original owner of the property, and as such, the suit and the appeal should be dismissed for non-joinder of necessary parties. Next para, upon hearing learned counsel for the parties, comma, we decide the matter as follows. There is no specific bar to substitution of the heirs of a deceased appellant in an appeal, even if no such substitution has been carried out in the suit from which the appeal arises. Next para, needless to say, comma, if such substitution is not carried out within time in the connected suit, comma, legal implications will follow in the suit, which indeed may ultimately affect the fate of the appeal. However, comma, per se, such non-impleadment stroke substitution does not debar the appellate court from allowing substitution, comma, since appeal is a different proceeding than the suit, comma, and the legal fiction of continuation of suit may not strictly be applicable in an appeal against an interlocutory order. Next para. Secondly, comma, in paragraph number 2, comma, it has been categorical, para 2 of the application, comma, it has been categorically stated that Arjo and Mouli are also the heirs and legal representatives of Bobby Das. Next para, although it has not been clearly mentioned as to them being the children from her previous husband Milan Kumar Das, comma, nonetheless, comma, the copies of the death certificates both of Mohanlal Das and Milan Kumar Das have been annexed to the present application. Such annexures, comma, in conjunction with the clear statement that Arjo and Moli are the children of late Bobby Das makes it amply clear that for the purpose of substitution, comma, a sufficient case has been made out both with regard to Arjo Das and Moli Das. For next para, in the event the contesting respondents wish to raise a plea as to those two persons being the children of late Bobby Das through Mohanlal Das, and therefore the appeal being bad for non-joinder of necessary parties at the inception, comma, it will be open to the said respondents to raise such point at the final hearing of the appeal. Full stop. However, comma, a sufficient case for substitution of the said 2 years has been made out in the application. Full stop. Even otherwise, comma, the rigors of timelines for implement of parties does not strictly apply in partition suits and appeals emanating out of such suits, comma, since partition is a continuing cause of action, and in any event, comma, even if there is a deficiency as to joinder of necessary parties, comma, the said defect can be cured the very next day, even if the suit or the appeal is dismissed, by filing a fresh suit on the continuing cause of action by impleading such omitted parties. Full stop. In order to avoid such unnecessary paraphernalia, comma, courts have consistently held that in the event an objection as to non-joinder is taken, comma, the same has to be taken at an earliest possible opportunity, and before dismissing the suit or appeal, comma, an opportunity of implement of the parties of the omitted parties ought to be given to the plaintiff stroke appellant. So following such principle, comma, in any event, comma, there is no bar per se in impleading the omitted parties even at the stage of substitution. Full stop. Hence, comma, in view of the above discussions, comma, can 3 of 2026 is partially allowed, comma, thereby directing Arjo Das and Moli Das, comma, as the particulars of whom have been mentioned in the chart and chart given in paragraph number 2 of the application, comma, to be substituted in place and stead of the deceased original appellant number 2, late Bobby Das. Full stop. The necessary consequential corrections to the memorandum of the appeal shall be carried out by the learned advocate in regard for the appellant during the course of the day. Full stop. Next para. Since Anikesh Das, comma, another heir of late Bobby Das is already on record, comma, no further direction need be passed in that regard. Full stop. Next para. We also make it clear that in view of Anikesh having attained majority in the meantime, comma, the prayer for him being represented by next friend also made in the application is not pressed by the petitioners. Full stop. No orders to cost. This is about Can 3.
Yes. Now, my lord, Can 2 is, my lord, extension of the interim order. My lord, initially, my lord, I instituted a suit for partition. There, my temporary injunction application was rejected on contest. Against that, I preferred an appeal. My lord, the division bench, coordinate bench had passed an ad interim order of injunction, my lord, which I seek extension.
That injunction is still pending.
That injunction, no, it has expired.
So you filed another injunction application, Can 1? No,
Can
no.
1?
That injunction application is still
Yes,
pending.
yes, Can injunction application is pending.
Why did you file another application? We can dispose of the injunction application itself.
My lord,
we have served on all.
We have served, my lord.
What is the nature of injunction? No, here. What is the nature of injunction?
Well, nature of injunction, my lord, would kindly take page 14 of Can 2, my lord.
Why was temporary injunction dismissed?
My lord, though the court has come to a finding that it is a joint property, yet, my lord, court dismissed my injunction application on the sole score that of non-joinder of necessary parties.
Which parties?
They had raised an objection that there are other co-sharers and they had ought to have been made parties to the proceeding.
Did they disclose the names of the co-sharers?
No, they did not disclose. And my lord, in my application, my lord, I had explained that In my injunction as well as in my plaint, I have explained that. Kindly take.
Why did you wait for so long to take out the application for extension? When did it expire?
My lord, it expired. My lord, from September, 12 weeks was granted, and immediately after my lord expiry, my lord, I have filed.
When did it expire?
My lord, 15th,
Calculate, tell us.
15th মানে হচ্ছে 3 মাস তাহলে হচ্ছে তোর 15-12 my lord, on 15th of December it expired.
What is the explanation for delay in
My
filing?
lord, it was directed to appear in the combined list, my lord. It did not
Yes.
appear, my lord, and on the reopening day of the court, my lord, we had filed both the applications. 5th of January, it was filed.
Yes, what do you say?
Regarding can 2, I have no copy in my head.
Don't have any copy?
No, my lord.
No, we'll dispose of can 1 itself.
Leaving to my lord. I'm
But-
totally handicapped as because I don't have the can 2 applications.
Can 1 you have?
Can 1 I am having.
You are deciding can 1.
Fine.
Can 1 itself is pending, so there's an identity prayer there also.
Fine.
You can decide on that also. Why shouldn't you grant injunction? Did you point out who are the omitted co-sharers?
Yeah, truly speaking, yesterday I got the brief from my senior. Reference advocate handed over the brief to my senior yesterday, and yesterday I got the brief.
Can 2 has been served on your client.
No, I am not aware as because the reference advocate has not served me.
Then we'll extend the interim order till disposal of can 1 and put can
No,
1
I
on
will
some other date.
Fine.
Then we're allowing can 2. From the affidavit of service filed today, comma, which is kept on record, comma, it transfers that all respondents have been served. Full stop. Accordingly, we take up can 2 of 2026 for hearing. Full stop. Next para. We find from the records that already a coordinate bench had admitted the appeal and granted an ad interim order of injunction which expired sometime in the middle of December 2025. Full stop. Although the present application for extension has been filed on January 6, 2026, comma, since an ad interim prayer was made in the parent injunction application bearing can 1 of 2025, comma, we deem the delay in making the application formally to be condonable. Full stop. Next para. In any event, comma, on a prima facie perusal of the materials before us, comma, we find that a strong prima facie case for hearing of the appeal has been made out as the learned trial judge refused temporary injunction primarily on the grounds that nothing has been proved to show that some of the defendants are trying to transfer the property in favor of third parties, as well as that the plaintiffs stroke appellants did not deal with the allegation made in the written statement to the effect that the suit is bad for non-joiner of some of the co-owners. So next para. Insofar as the first ground is concerned, comma, we are prima facie of the opinion that an injunction application is primarily decided on the averments made on oath, and there may not be any particular document to show the alleged attempts of some of the defendants to transfer the property in favor of third parties. Full stop. Next para. Insofar as non-joinder is concerned, comma, in a suit for partition, comma, as discussed above, comma, such defect can be cured at any point of time. However, comma, conspicuously, comma, it does not appear that the specific names and particulars of the omitted co-sharers were disclosed in the written statement filed by the contesting defendants, comma, as such, rendering the allegation of non-joinder of necessary parties vague. Full stop. Next para. Thus, comma, the temporary injunction application, comma, in our prima facie opinion, comma, ought not to have been dismissed on such grounds, despite the learned trial judge having held that the property was joined and there was no partition by meets and bounds. Accordingly, we reimpose the injunction granted earlier and restrain the respondents' opposite parties from changing the nature and character of the suit property, as well as from selling, transferring, alienating, and or creating any third-party interest in respect thereof till disposal of Can 1 of 2025. Both parties, all the parties shall maintain status quo as regards possession in respect of the suit property, also till disposal of Can 1 of 2025. Can 2 of 2026 is accordingly disposed of without any orders to costs. The respondents shall file their affidavits in opposition, if any, to Can 1 of 2025 within how much time should be? 3 weeks? Within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on May 11, 2026.
My lord, one humble sir. Can you make it 4 weeks, my lord? Let's.
ওটা 3 weeks টা 4 weeks করে দিন আর 1 week যেটা আছে সেটা fortnight করে দিন in the monthly list of June 2026.
Or the affidavit of service be kept on record.
We have incorporated in one of the paragraphs. Yes.
We have soft copy of the my lord limitation application along with the other application. My lord, limitation was not applicable in this case, my lord. It was my mistake, my lord. I could not see the other day. My lord, it was within 90 days, but my lord.
Within 90 days?
Yes, my lord. But
Stamp reporter's report says limitation.
There was no report. It was an application filed by us. My lord, thinking 30 days was the limitation period. My lord, kindly condones that.
Why 30 days? This is not city civil code. You have been doing mostly matters of city civil code, that's why.
My learned friends are.
Because you do mostly matters from city civil code.
Yes, my lord.
That happened to me always. I did mostly matters from South 24 Parganas and sometimes in other matters also that crept in, copy paste. Very well. So you're not pressing this application.
My lord, there is.
You have checked up, it's within.
My lord, the 25th of my lord, September, we have filed. Order dated 13th of August.
Learned counsel appearing for the appellant submits that Can 1 of 2025 was erroneously mentioned, erroneously filed for condonation of the delay in preferring the purported delay in preferring the appeal, although actually there is no delay in preferring the same. Accordingly, Can 1 of 2025 is dismissed on the prayer of the appellants as not pressed without any orders to costs. What is the matter?
My lord, Can 2 is. My lord,
appeal
we
has
have
to be
filed.
admitted for
My lord.
Your Lordship, I'm for the respondent.
You have been served with copies, affidavit of service.
As we have recently got the brief, I'm humbly praying that a 3 weeks accommodation shall be given. We will file the
grant injunction and then give you 3 weeks. No difficulty. We don't have any difficulty. They don't have any difficulty. It was not formally admitted.
No. Because, my lord, this Can 1 was there, my lord, your lordship.
What is the satisfying
Kindly says page 127, my lord, the impugned order.
No, we are following the memo. So,
my lord, from the memo, my lord, it is in 1-page order, my lord.
What is the suit
refusal
for?
of the, my lord, suit for damages for defamation, my lord.
Your suit?
My suit. The husband's suit against the wife, my lord. The respondent is the wife.
Very good.
My lord, our cause of action arose from, my lord, 20th of July 2025.
No chance of reconciliation?
My lord, as of now, no.
Very well. Yes.
My lord, all the posts in the social media, my lord, whereof the defamatory posts whereof, my lord, post 20th of July 2025. That was our cause of action before the, my lord, the learned court. My lord, learned court observed that, however, it is evident from the documents filed by the plaintiffs that the latest post of the defendant pertains to 25th of July 2024. And no other current posts have been produced by the plaintiffs. Therefore, my lord, so it was, my lord, on the basis of this erroneous, my lord, observation that.
So what was the last date?
My lord, my cause of action arose from 20th of July 2025.
Oh,
all the posts were of, yes, and the other continuous recurring my lord, posts.
So you could have waited for some time until they made another post and then have a current cause of action. Anyway, let us see some of the posts which are
My
most
lord,
derogated.
page 56, 58 onwards. My lord, we have my
We
lord,
are not interested in the dirty linen, only the most scandalous post according to you.
103. 103. 103. 103. Their mother-in-law.
my lord 103. How
You have a
she
child
has-
also. You have a child.
Yes, my lord, she is using the picture of the child. The child is in my custody, living in the US,
And that too was a special child.
and that too he is a special child using the picture. And this is how she has defamed my mother, my lord. Page 103.
And 94 is myself. Page 94.
And 94, my lord, are my
Applicant number two.
using my pictures,
Applicant number 2.
the husband's picture.
There are comments also.
Yes. What's up the injunction? Let us.
My lord, restraining the wife not to make any posts in the social media.
Service of this, the advocate.
ওটা পরে পরে। ওটা বললে দিচ্ছে আরো নেই।
Very well.
Nature of the lady.
The present appeal arises out of a suit for damages stroke compensation on the allegation of defamation committed by the defendant stroke respondent wife against the appellant number 1, comma, her mother-in-law,
My lord.
and the appellant number 2, comma, her husband. Full stop. Next para. The learned trial judge, comma, although considered the purported defamatory posts, scandalous and derogatory posts annexed to the temporary injunction application, comma, refused to grant injunction primarily on the refused to grant ad interim injunction primarily on the premise that the latest post of the defendant pertains to July 25, 2024, and as such, there was no urgency in the matter. However, comma, learned counsel for the appellant points out from the averments made in the injunction application as well as the annexures thereto that the allegation of the plaintiff stroke appellants was that such defamatory posts were made on and from July 20, 2025, comma, upon the plaintiff's appellants having refused the exorbitant amounts of money. না এটা দরকার নেই after থেকে কেটে দিন comma which is also reflected in the impugned order itself. Full stop. Accordingly, such premise was prima facie perverse. Full stop. Even otherwise, comma, from the annexures to the injunction application, we are sufficiently satisfied of the prima facie case made out by the appellant with regard to the social media posts being made by the respondent to be scandalous, derogatory, and defamatory and insulting for the appellants. Full stop. Accordingly, the respondent is hereby restrained by an order of injunction from making any post and or publication in
Your
any
Lordship.
media.
Your Lordship, as
comma,
per the
social-
instructions I have, my senior is
quickly, we are in the
my
middle of a
senior is
sentence.
outside of the court
Maybe.
right now. My only prayer is 3 weeks may be given.
Any media, comma, social or otherwise, comma, which may be derogatory, defamatory, comma, sarcastic, and or scandalous, and may bring down the social prestige of the may demean the social prestige of the appellants in any manner whatsoever till disposal of the application bearing can 2 of 2025. Full stop. The respondent shall file her affidavit in opposition to can 2 of 2025 within 3 weeks from date. 3 weeks. 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall next be listed on May 11, 2026.
Not only seeking one indulgence, she should not use the picture of the child.
None of them. None of them.
Picture of the child blanket ban would be a gag order because
As your lordship, as
he may use the picture of a child in a instance also.
My lord,
It's a-
this is my lord,
Oh,
your
the
lordship,
child is with you.
child is with me. She is reading in a school in the US, my lord, and this is not a local newspaper, my lord. She is making. All these can be, my lord, seen by his peers.
যেটা বললাম restraint from doing such সেখানে and stroke or using the photograph of the minor child of the parties in the light of the above restrictions.
Grateful.
Whatever that means.
Grateful.
Yes. So she can use the picture otherwise. She can say my child, but not in the light of those restrictions.
Your lordship, we will place that, my lord, till 2000, yes, all the posts were happy posts. Till, my lord, I had been sending money.
Some of those pictures. Not very happy now.
Not very happy.
Yes.
My lord,
Yes, Mr. Ahmed, what is the matter?
there was a direction for filing a supplementary affidavit, my lord. I was supposed to file, but there was a direction to file it within a fortnight, my lord. Unfortunately, my lord, that could not be done.
It is now ready.
It's ready, and I could not
No
serve
copy
the
given.
copy has not been served upon the rest of the, my lord, respondents and the respondents who are being.
You have filed your opposition or you will file now today?
No, my
But
lord.
they have not been served with the
My lord has given the passed a direction, my lord, on the last occasion
No,
that
no, what
they
has
should
not been served on them?
supplementary
supplementary
affidavit.
affidavit.
Mr. Ahmed, why should we permit you now?
My lord,
Pass the direction on 16th of March.
that was unfortunately, my lord, they're ongoing all this SI process. My lord, my clients are, they are very, they have been running from pillar to post for this.
This is credible, very credible.
My lord,
Particularly looking at the fact.
kindly keep it, my lord, next 2 weeks hence, my lord. In the meantime, I will serve the copy, my lord.
Yes, you know. Yes, right.
I was waiting for that, my lord.
Oh, sorry.
I was waiting
Elaborate
for
on
that.
Very credible. We have been seeing other people also.
Oppose on that ground. That's why I did not open my mouth. Yes, yes.
So, you're filing it today?
Well, I will file it today.
File the supplementary, give them copies
Well,
today.
I'll serve a copy to them, my lord, today. By today, and rest of the, my lord, respondent, I have to serve them by post, my lord, because they did not appear.
The delay in filing the supplementary affidavit, the supplementary affidavit filed by the appellants today be kept on record. First of the delay in filing the same is condoned on the oral prayer made by learned counsel for the appellants in view of the unavoidable circumstances under which such delay occurred, due to the appellants allegedly suffering inconveniences due to the ongoing SIR exercise in the state of West Bengal. We'll put it in our order.
No.
So next para, copies of the same shall be served on the learned advocates for the respondents by tomorrow. We are making it by tomorrow for abundant caution, but do it today.
Well, I'll give it to him. I'm handing it over right now.
By
Records that, my lord, accordingly.
After the
he has not yet handed over. We won't
I'll serve.
My lord,
not handed over. Not sufficient copies that we can see. That's why we see.
he is still having the copies.
He doesn't have all the copies. By tomorrow, full stop. Next para. The time for filing composite affidavits in opposition to the condonation application and the supplementary affidavit is extended for
3 weeks. 1 week, my lord. 1 week will do.
2 weeks. We are going to till a fortnight from date. Full stop. Reply thereto, if any, shall be filed within a week thereafter. The application shall next be listed on May 11, 2026.
Very well.
I'm grateful.
So great.
Grateful. Copy শোন না তোর তো নম্বর আছে এর নম্বর নেই তুই নম্বরটা ভাই দিয়ে দাও ধরে কপি
I'm so grateful.
27 minute, Mr. Bhattacharya. Mr. Shona Bhattacharya.
You are sufficiently competent.
Item number 27. If I may, although I have written a letter.
You are also sufficiently competent. Yes, Mr. Mukherjee.
Instruction to take.
Refuse.
In the court below, they are They are praying for adjournment, showing the appeal is pending.
We won't grant the adjournment.
Now, my
We'll move the matter.
only thing is that, my lord, I must point out that, my lord, they ought to have filed two appeal. Why, my lord? I filed a suit for eviction of a licensee.
Right.
They appeared, they filed written statement accompanied with counterclaim saying that they are the tenant. My suit has been declared, counterclaim dismissed. Two appeal has been filed.
Two appeals have been filed
before the London district,
Achha.
first appellate court.
Right.
Both the appeal has been dismissed. Now it appears that one SAT 14 of 26, my lord, has been filed.
This is in connection with which appeal?
That I don't know. Nothing has been served, whether it is against a counterclaim or against my decree. Because in the eviction suit, when I filed the execution case,
If the other one stands, then he's entitled to eviction as a licensee. Your defense is this is you take instruction. We are not passing it over. You take instruction on this. We'll record his preliminary objection. You take instructions on this. We'll you come back come back tomorrow. First take instructions and come back. You are appearing for which respondent, Mr. Mukherjee?
But I am the plaintiff.
Sole. Learned counsel for the plaintiff respondent, comma, at the outset, comma, takes a preliminary objection insofar as the present second appeal emanates from a suit for eviction of licensee filed by the plaintiff respondent, comma, in which a counterclaim was filed by the defendant stroke present appellants seeking a declaration of their tenancy rights. So, while the suit was decreed, comma, the counterclaim was dismissed, comma, resulting in two separate title appeals being filed therefrom, which were also dismissed by the judgment, common judgment impugned in the second appeal. So, next para, it is submitted that in the event either of the judgments, comma, in the counterclaim or the suit, comma, remain unassailed, comma, the effect will be that the plaintiff should be automatically entitled to a dismissal in the other. Full stop. Next para. Accordingly, learned counsel appearing for the appellants is requested to take instructions as to whether any steps have been taken for challenging the other decree and stroke, or if not, comma, as to the explanation regarding the same. So for such purpose, comma, the matter is adjourned for the day. You tell Mr. Bhattacharya? Because you understand the thing. Because if your declaration of tenancy goes, then you are a licensee, automatically the licensee eviction, nothing is required to be proved almost. And vice versa. And if you are proved to be a tenant, very well. Be happy with that, license eviction degree remains.
But that is as it appears from her memorandum of appeal, which has been just seen, that there are two title appeal. One is 155, one is 156. Now
both have been challenged.
No, here my
155 has been
155 has been challenged.
That is which?
What?
That is which one? Anyway, the effect is the same.
Let a copy be served also.
Copy of what? Memo?
Memo and the whatever stay application or like, because
Sir, I says no. He is a stronger talisman than it. Yes.
Copy this. In February, we wrote a letter to them.
Copy?
February 2026, we wrote
Give copies to them, no difficulty.
I shall see.
First, take instruction from Mr. Bhattacharya whether you should give a copy. Then only.
Mind.
Regarding that, you take instruction. Yes,
Great,
Mr. Rai.
fine.
Call on the next one. 28, Mr. Rai.
I am appealing for the plaintiff appellant. The suit for specific purpose of contract. Well, there is a caveat. Well, I have some
Received on the advocate. Yes. Suit for specific purpose dismissed.
Dismissed by both the courts. The trial court dismissed my suit on the ground there is no element regarding readiness and willingness. Appeal court dismissed by
Element is very clear because you asked for adjournment on the last occasion also. Readiness and willingness cannot be a strong point. Yes.
And the appeal court is of the opinion the suit is barred by limitation.
In addition to that,
no, that is why, my lord, kindly turn to first. I draw your lord's attention so the trial court is concerned. The relevant. Will Lordship, can you turn to page 20?
Yes, page 20.
So from the So from the evidence of PW1, DW1, my lord, fine. It appears to me that the plaintiff has contended that he has paid the inter-concession money rupees 1 lakh on such as, but Exhibit 2 goes to show that rupees 20,000 was paid to defendant only on such and such date after lapse of 4 years from the date of execution. So called the sale received dated 20th July 2004. There is also no mention in the mode of payment made by them in the receipt, sale receipt, though there is mentioned consideration money for sale of rupees 1 lakh. Moreover, PW1 himself admitted consideration that he is not given possession of the property on the date of execution of the sale receipt, thereby contradicted his own case. So the evidence that the Exhibit 3 has not been acted upon by the parties, plaintiffs failed to prove they are not willing to ready to discharge the part of contract.
You said there was a government embargo of
Yes, there is a government at the relevant point. There is a government embargo regarding registration.
what embargo?
For registering any document in the particular ADSR office. Same was lifted in the 2005, but it was not within our knowledge, be as it may, my lord. If 2008, keeping aside everything, 2008 they have admitted yes they have received the amount. Then, my lord, whether this time can be termed to be an essence of contract. Is a immovable property. By act of the parties, if it appears they are condoned the delay and accepted the money, whether it can be termed to be a essence of contract. My lord, appeals court's findings over the limitation is concerned, your lordship will find that portion, page 15 of the appeals court judgment.
This was the only ground on which it was dismissed.
More or less, these are the two grounds based on which, my lord, trial court, that is the only ground.
Government embargo, you did not prove it or something.
No, it was there. It is admitted that after 2005. There is no dispute because the ADSR from the ADSR office, there is evidence also. And it is
not given possession, delivered possession. It was an oral agreement.
No, written agreement.
Delivered a possession anyway.
Now, my lord, coming to the issue, page 50, internal page 15 of the appeals court judgment, my lord will find.
Appeal code, you were saying apex code. Bad habit, yes.
No.
Yes.
Coming to the issue whether the suit is barred by law of limitation under Article 54 of the Limitation Act, provides the limitation period of filing a suit for specific purposes of contract and prescribes therein a period of 3 years from the date fixed for the performance.
No, appeal could reverse the other finding in your favor.
Yes.
Appeal could in the previous page itself, it is evident from the above defendant has refused to fulfill her obligations. Thus, the instant issue is found to be in favor of the plaintiff.
But
unlike the determination of the trial. So that was reversed by
reversed by the appeal court proceeded to dismiss by appeal on that
not on both grounds.
Not on both grounds, only on the different ground.
Let us see.
3 years from the date fixed for performance, or if no such date is fixed when the plaintiff notices the performance is refused for filing of such suit. In the present case, Exhibit 3, for which is the agreement for sale, does not mention in date of performance of the registration of the sale deed therein, but it does mention that the said registration of sale agreement would be done as and when government embargo was lifted, which implies that the date of performance of the contract is agreed to be the date of lifting of the embargo, which means that such limitation should run from the date of the embargo was lifted on and from 19/7/2005 and would continue 3 years, that is on 18 July 2008. As the
when was the last payment received by them?
2008. That is the trial court finding, my lord. It is held within
the period. Did not come within 3 years from that also?
Yes, my lord. Within that 3 years.
2012 we have filed. 2012 is 4 years.
No, my lord.
2008.
No, my lord. It was received on 10/12/2008. Last payment received.
10/12?
2008.
10/12/2008.
Yes, my lord. And the trial court finding, my lord, some of the limitation, my lord, if you logically turn to that portion, page 23 of the trial court judgment. Last paragraph, my lord, Article 54, my lord, got it. Though the instance would didn't.
Yes. The present, this second appeal will be heard on the following substantial questions of law: whether the learned first appellate judge substantially erred in law in dismissing the plaintiff/appellant's suit for specific performance of contract on the ground of limitation in view of the last payment that is admitted, that last
payment. Yes. In the register that was admitted.
Of the last payment of consideration amount being made admittedly on November 30, 2012, and the suit was filed when?
In the year 2012, my lord, last when notice is given 3 years not bear the date of performance. Exhibit 2 shows that the notice was given to defendant on 6/7/2011. That the instance suit is filed within the period of limitation, failed to prove that the performance of a contract. Yeah,
No.
Suit filed 30/11/2012.
The last payment was when?
Last payment is
30/12 itself,
10/12/2008. Page 20, your lordship got it.
Oh, acha. Last payment যেটা ডেট বললাম ওটা
10/12
December 10, 2008.
So
December 12, 2008 যেটা পেমেন্টের ডেট।
last payment date. And after the
And the suit
constitution-
having been filed on November 30, 2012, comma, that is within 3 years therefrom. Next হচ্ছে, we need not frame any issue on the question on the other point because
Because
the
other
has reversed.
in my favor it was reversed by the appellate court.
Substantial question of law করে একটাই থাকে।
And there is an application for injunction if not to transfer alien it.
The
That is
respondent, since affidavit of service filed to be kept on record, full-stop, despite service, comma, none appears for the respondent caveator. Full-stop, but since there is a caveat, we'll keep it pending there, please. The respondent shall remain restrained by an order of injunction from selling, transferring, alienating, or creating any third-party interest in respect of the suit property and/or from changing the nature and character thereof till disposal of Can 1 of 2026. Full-stop. Affidavit in opposition to the application, comma, if any, shall be filed within 3 weeks from date. Full-stop. Reply, if any, shall be filed within a fortnight thereafter. Full-stop. The application shall be listed next in the monthly list of June 2026. Full-stop. A server copy of this order shall be served by the learned advocate on record for the appellants on the learned advocate on record for the caveator stroke
And also
respondents.
the respondents, my lord, because my lord,
Why? No, no.
the learned advocate on record and because there is no appearance. I'll serve, my lord.
Learned advocate on record for the respondent within a week from date. He will be embarrassed otherwise.
No, I'll serve both.
Okay. ভুল বলেছেন তো ঠিক।
Beg your pardon?
আগে one second, Mr.
Yeah.
No, but it is then not within
The notice was issued after 2008. I have on the appellate court held in the year 2008. Time expired. Validly consider the appellate court judgment.
No. When your cause of action started from when?
The notice was issued for execution of the deed that your lordship find at page 20
of the
page 20 of the yes, page 23. Exhibit 2, you lordship find Exhibit 2 bears the date of performance of contract. Exhibit 2 goes to show that the notice was given to defendant number 6/7/2011 and the instance case was filed in the 30/11/2012 and that is well within the stipulated period of limitation. Though the instance suit is filed within the period of limitation, but they have failed to prove that they had performed part of their contract. Hence, the Exhibit 3 does not enforceable contract in the eye of law. My condition is that 2008 they have received the payment.
Substantial question plot কেটে দিয়ে change করে দেব।
And the appeals court held that
whether the learned
2005 is the date for
first appellate court substantially erred in law in dismissing the suit for specific performance of contract on the ground of limitation by overlooking the categorical finding of the trial court to the effect that it was evident from Exhibit 2 that notice for performance of the contract was given to the defendant on July 6, 2011, comma, upon refusal of which, comma, the suit was filed on
30th November 2000.
November 30, 2012, comma, that is well within the stipulated period of limitation.
Appeal court is of the opinion 18 July 2008 is the date of for the purpose of limitation.
এটা আপনারটা না। রিটার্নেবল কবে করলাম? হ্যাঁ, জুন 22 টা হয়ে যাবে ওটাও কেটে দাও থ্যাংক ইউ জুন 22 না করে রিটার্নেবল বিফোর দি অ্যাপ্রোপ্রিয়েট shall be listed next before the appropriate learned single judge having determination after the above timeline for filing of affidavits is over, comma, subject to being mentioned by the parties. Okay? Next.
Nine Lordship, I beg to appear on behalf of the appellant. Lordship, CAN 3 is an application for substitution of the plaintiff respondent number 1, Lordship. Lordship, may I be permitted to serve this upon the parties and come back? Also, Lordship, there is one more defect, Lordship, in the appellate court decree. Lordship, the names of the original deceased defendant still appears.
It was adjourned on your prayer on 1st of October 2024.
Lordship, I do not know. I'm standing as a proxy for Mr. Bordhon today. Because on 2025, Lordship, 18th of March 2025, Lordship, the respondent number 1 has expired. We have taken out an application that is CAN 3.
CAN 3 টা আছে এখানে কোথায় তলায় নাকি ওটা CAN 3 সব সেলাই আলাদা আছে
Lordship, this has to be served.
What are the other applications? CAN 1 and 2?
CAN 1 is, Lordship, for injunction, and 2 is for under Order 41, Rule 27 for additional evidence, Lordship.
What is the defect?
Defect কি আছে গৌরব?
No defect now. Defect removed. There is no defect now. This CAN 3 is within time.
It is within time, Lordship, but it has not been served, I am told.
Substitution within time served for the case. Who has died? Your client or?
No, no, the plaintiff, Lordship, the plaintiff respondent number 1.
He was the sole plaintiff.
Yes.
He has died.
Lordship, the
sole plaintiff has died. There was one respondent only.
No, not all. Respondents were many, Lordship.
Respondent number 2 is an addition of the parties.
Lordship, plaintiffs, there were five plaintiffs.
Principal plaintiff respondent you have described in CAN 3 as only one. Ekhane principal plaintiff you have mentioned only one person as principal plaintiff.
Lordship will kindly pardon me for saying this, but this was filed by the erstwhile advocate on record. I find
the others have been described as pro forma plaintiff. Pro forma plaintiff. Okay. Anyway, there is no question of why should you serve? I mean, within time, the Lojima court could do it without service. We are allowing this application. But then it will be in difficulty immediately after that.
No, because then I will make another prayer, Lordship, because another application has to be taken out for striking out the name of the respondent number 2.
Why?
She has also expired. Her name was changed in the memorandum.
Goes out of the list, you do those things and then come back.
Lordship.
Learned counsel for the appellant submits that an application is required to be filed for striking out the name of respondent number 2. Push-up. Such leave is granted. Push-up, let the matter go out of the list for the present with liberty to mention for inclusion in the list as and when such application is filed.
I'm grateful.
Listed by that.
Not my appeal.
Proforma plaintiff, can see the last proforma plaintiff. You also have a proforma plaintiff, in your school.
I was saying the CPC doesn't talk about a pro forma defendant, neither a pro forma plaintiff. No, I have never.
Exactly. No, you're right.
But I
We
have never
we have
heard of.
evolved that.
I have never heard of a pro forma plaintiff before.
Tentative
I've
sort
never
of
come
unsure
across this.
unsure, hesitant plaintiff probably. Yes, Mr. Abdul Basit,
I'll
sorry.
just take 2 minutes on the fact, not I'm a secured creditor against a company, not the loan of 130 crores odd is not secured by pledge of 100% shares of the company. In addition, there are other securities. Now, there are defaults. I shoot off some default notices, but the main loan itself was not then due. Then the loan becomes due. Before I shoot off my notices invoking the pledge, what they do is they go and file a collusive suit in the city civil court, getting a injunction on the basis of a small alleged loan of 2.35 crores alleged to have been given by the other plaintiff, not in the city civil court suit. He claims, and that's a later loan. He claims that against that he gets an injunction against the defendant company there, which would have been my creditor, injunction restraining them from dealing with those shares. Now, that is not served on me. When I write to them saying, look, I've invoked the pledge, please transfer the shares in my favor, then they hold up this order that is obtained there. Now, this order is there, they keep on extending it.
Defendant there is the company, of whose shares have been pledged to with you.
Yes. Now, so this collusive proceeding, they keep on extending the interim order there, no attempt to have it vacated, they don't inform me. Although the terms of my loan agreement say very clearly that, look, you can't deal with my pledged shares. If you do anything, if there's anything which happens prejudicially, you have to inform me. Nothing done. When I invoke the pledge, then they show, look, there is an order, I can't do this. They write to the DMAT agent saying, don't allow any transfer. This is the situation. Now, for whatever reason, we went in and stuck our neck into that suit by filing Order 1, Rule 10, which is ultimately dismissed in December 2025. The interim order was passed long before. Once it is dismissed, I've come up challenging that order. So that's why the first one application for leave to appeal, I'm not a party to the suit, but I'm prejudicially affected. That is one application. Second is for condonation of delay in case the point is taken, but my delay would start running from the date when I'm not impleaded as a party to the suit, which is December. So that delay will.
What is the delay from that date?
Yes, from that date.
What is the delay from that?
35 days between the filing of the appeal.
It would be years if otherwise.
It would be a year and a half otherwise.
20 days.
Yes.
It would be a year and a half otherwise. So that's the second.
So on the condonation application, let us hear them, Mr. Sinha first.
Your Lordship, forget about the condemnation application. I want to first hear the one they are not.
You can allow it and
leave to appeal. The leave to appeal. That is the first application I want to read. This is a very nice story which has been.
No, because Order 1 Rule 10 has been refused.
Not only forget about the Order 1 Rule 10, rejection of the Order 1 Rule 10.
Forget Order 1 Rule 10.
Absolutely.
They are very good at forgetting.
Who is collusion? Who is in collusion is the most important thing.
Can it be done before leave to appeal is given?
Shrey Equipment
Can you argue the merits before
No, I'm not. Unfortunately, my learned friend opened the Pandora's box by saying everything about without going into the leave to appeal.
But first address the leave to appeal.
Well, your Lordship will take the leave to appeal application. All the story that has been said, where is it? In the leave to appeal. Please come to the leave to appeal. And we have filed an opposition to that.
You have filed?
Yes, your Lordship, and they have not filed a rejoinder to that.
There was no direction. Yes, not just forwarded something.
We have given.
No, it was filed previously, brother.
Yes.
Yes, on the last day he filed it, but there was no direction to file any act.
Your Lordship will come to paragraph page 3 of that application. Now, what is it say in paragraph 2? I'll just take your time to take 3 paragraphs.
Yes,
because this is what they have said.
Absolutely. Yes.
the petitioner had by a letter dated so and so indicated its intention to invoke the pledge of shares by the respondent number 3. In response, the respondent number 2 had issued a letter dated. Now, who is respondent number 2? That is Kitply. Who owns the 100% shares of that company? My learned friends' clients. They own that company and they are saying that company which they own is in collusion with me.
The 100% shares of this company was pledged. They own actually.
Yes.
100%.
100%. Kitply. Response had issued a letter dated 13/25, wherein the respondent number 2 made reference to the impugned order to state that there is an injunction on the pledged shares. Their company is telling the parent company that there is an injunction.
My company.
100% shareholding.
I have no shares. But I don't know where he's getting that. I have 0 shares. The shares are pledged to me.
Kitply shares are pledged to you. That is
Yes,
what we
pledged.
asked you.
I am not the holder. He says I am
No.
100% shareholder. That's what he
How
said.
can he be 100? If those are pledged to him, he is not the 100.
Very well. Pledged.
That was the company of, that is the question we asked you.
But just to make it clear, see the cost title, I'll just explain to you.
There is another
Not
company,
just take,
another
not just take
Shrey
the-
company.
Not just take the cost title, I'll explain it so there's no further confusion. Not Shrey, I am the lender.
So the NBFC
Shrey-
lender, yes.
Now, my lord,
So just
No,
does
okay,
it.
may I just come to the
Avigyana,
paragraphs
but I'll
first?
just take
No,
one.
no, come to the paragraphs
Let them
first.
explain the
Okay.
concept first.
Lord,
Yes.
Avigyana is the plaintiff in this city civil court suit. He claims to have lent 2.35 crores recently, long after my pledge. Lord, Kitply is the company where Lord 3 Platinum owns 100% of the shares.
Platinum is the borrower.
No, Kitply is the borrower. Platinum is the 100% shareholder of Kitply.
And the pledger.
And Platinum, which holds this 100% shares, has pledged these shares to me. This is this.
Yes.
So that
Now
this
your
confusion doesn't happen.
Right.
Okay.
And you are for Avigna.
I'm for it. Now your lordship comes to this. What are they saying? In order to state there is an injunction on the pledged shares. Along with the letter dated so and so, the petitioner has forwarded a copy of the order dated May 22, 2024. A copy of the order dated May 24 as made available to the petitioner by the respondent number 2 is annexed hereto and marked so and so. The petitioner had no knowledge and or knowledge of the aforesaid order as the petitioner was not party to the said proceeding. Very well. What to say next? Subsequently, the petitioner filed an application under Order 1 Rule 10 in the titled suit proceedings before the City Civil Court, Kolkata, praying for leave to intervene in the suit and to be added as party to the proceedings. However, by order dated so and so, the application for addition of party of the petitioner to the said suit has been rejected. This is one. Next, the petitioner has applied for obtaining a certified copy of the impugned order. The petitioner has, however, been advised as the petitioner is not a party to the suit, no such certified copy shall be made over. In view of the aforementioned, the petitioner craves leave to prefer an instant appeal without the certified copy of the impugned judgment and order dated so and so. That the right of the petitioner is adversely affected by the impugned judgment. So, in that judgment, unless leave is granted. So, how they have been aggrieved? How are they aggrieved? There is no pleading. All they say is basically that they are filing without a certified copy. Now, please look at the prayer. Please look at the prayer. Leave may be granted to file appeal against and by the impugned judgment so and so without the certified copy. This is the prayer. Where is the prayer that they are an aggrieved party? Where is the pleading how they have been aggrieved? And I'll show Supreme Court judgments which say that they have to, for getting this relief, they have to first demonstrate. There has to be express and clear demonstration of the fact that they have been aggrieved in how. And your lordship, there are umpteen number of judgments, mostly from England though, on the common law, which say that an injunction application works in personam. It's not in rem. So an injunction application cannot be equated with a charge. And as such, that cannot be that a third party who is not otherwise involved in a suit, in a matter in personam, can say they are being aggrieved. But that's on law, Your Lordship. First, there has to be pleadings. There are no pleadings in this case. Your Lordship, we have expressly stated that in our affidavit in opposition, that there are no pleadings. There is nothing to demonstrate. Judgment allow, Supreme Court judgment allow. Copies.
Paragraph number 2, they have indicated the reason.
Your Lordship, they have only indicated the fact that there are some pledges in
No, they say that they had by a letter indicated its intention to invoke the pledge. In response, they were informed that there's an injunction order which restrains them from.
They themselves have also obtained an injunction order under Section 9 in the arbitration.
That is different. But
Yes.
for the purpose of this appeal,
For the purpose
they
of
sought to invoke the pledge when they were informed there's an injunction, so they cannot do it. So
Your
isn't
Lordship,
that
may I-
sufficient?
Your Lordship, first, how is that sufficient against them? That is exactly the point. They have to say that. How are they aggrieved? Somebody may say anything.
So they seek to invoke certain pledged shares.
Between me and them, if he has a superior right, he will try to do that. If he has a superior right, then he will do it.
But his right to have the pledge invoked is curtailed by this injunction.
It is also curtailed, Your Lordship, by their own application under Section 9, where they have also
That's
obtained.
a different proportion. We are not on any Section 9 here.
Very well,
So
Your
far as
Lordship.
this order is
Very well.
concerned,
Very well, Your Lordship.
isn't this sufficient to say I want to invoke a pledge? There is a pledge of this company's shares in my favor. I want to invoke that. When I go and do that, I find that due to the injunction, I cannot invoke the pledge.
Your Lordship,
That is there. They are sufficiently aggrieved.
Your
Why
Lordship,
not?
no, Your Lordship. They do not say. Somebody says that this is there. Where is the pleading which says that I am aggrieved because of that? They have not
Be
said
happy
so.
with that language aggrieved or
Not only that. Explain, because as I said, Your Lordship, as I said, that injunction only works inter se the parties.
one of the parties is a company of whose shares have been pledged to them.
Maybe that
How can they invoke the pledge if that party is restrained by an order of injunction?
Judgment in even. Very well.
If the company of the shares of which has been pledged with them, 100% shares,
Yes, Your Lordship.
that is restrained from transferring those shares, then how can they invoke the pledge?
Your Lordship, may
It's very clear.
I didn't get your question. I'm sorry.
A company,
Yes.
the
Kitply
100%
is the
shares of the company, 100% shares of Kitply is pledged to them.
Yes, Your Lordship.
If the pledge is to be invoked, those shares have to go to them. They can
Lordship
deal with
will
the shares.
Your Lordship will
Can
see-
it be done in view of this injunction? If
Your
you say
Lordship will
yes,
see the-
then we'll record that and
If Your Lordship will see
let
the
them carry
language-
that stand to the trial court.
Yes, Your Lordship will take the injunction order.
No, it's the annex to this application.
Yes, that is what I'm saying.
Yes, we are
Yes,
there. We were
comes
looking
to
at
that.
that.
Yes. Comes to that.
Yes. 1 and
What
2 restrained from
comes to-
alienating movable property assets.
Yes.
Including shares.
Yes.
1 and 2 are Kitply and someone else.
Are hereby restrained from alienating the movable and or immovable assets, including the shares of the defendant number 1 company, described in the schedule A and B of the plea, without the leave of this court till next date.
Review number 1 is Kitply.
Yes.
So they cannot
Defendant
deal
num-
with the shares or alienate those.
They cannot alienate those, but Your Lordship, what I am only indicating is this. If they say that there is a superior right that they have, if they have a superior right, which they say
That
they
will be
have,
decided in the appeal. That will be decided in the appeal. But their rights are infringed sufficient for them to get a leave to prefer an appeal. That is clear. Where is the question of judgment in rem and all these things? This affects the company of whose shares
All
are
I'm-
pledged to them.
Your Lordship,
It's not a third party. It is the company whose shares are pledged to them. that itself is restrained. This is a difficulty with the juristic company.
No, Your Lordship, what I was indicating was this. Your Lordship will just give me, but judgments have actually not come. That's why I'm unfortunate.
They have not come, not delivered, or
No, not come, not delivered also, but a preferable judgment perhaps has not been delivered. But the thing is that
we can take care of that portion, but
yes, just give me a
having
moment.
not physically arrived, we cannot do it. Which ones have not come? The English ones or the Indian ones?
Both, I guess.
Both, neither have come.
Neither have come. Your Lordship. Please, please.
We are allowing the application to cite those
Your
post
Lordship,
facto.
Your Lordship, may I just I will just indicate one judgment. Your Lordship, this is Your Lordship's judgment.
Wrong. Wrong.
Justice Sanjeev Banerjee.
No, no.
Indian bench.
With Justice Sanjeev Banerjee, I withdraw.
No, no. Devan Kankaria versus Salpuria investment.
Single.
No, division bench judgment, Your Lordship.
On what proposition?
This proposition about leave to appeal.
What does it say?
It says to allay the apprehension of the appellant as regards the rights of the appellant in the immovable property being
They only said that they searched by the keyword of my name.
The
provision may be something entirely different. That worked in certain courts previously. You know that.
And Mr. Bordhon was very, very good at this.
But Mr. Bordhon is.
No, I'm saying when it
Yes.
comes to that, not
Does that
any
case-
court.
yes, yes.
Any court. Not
He got caught in several matters. Got caught.
I don't know how he does it, but normal
Right,
search is
us. That was the key word for the search. No, in certain courts it worked also. The name would supply a different proposition of law. So that you know.
not, it
All of
ought
you
to
know.
work. Your lordship is bound by your lordship's own judgment.
Not by the name. Thankfully.
I'll just read 3-4 paragraphs.
The relevant ones, Mr.
Yes,
Missionary, you definitely can.
I'll just
Absolutely coordinate.
Paragraph 5. As such, it is submitted that by the grant of injunction, the rights of the appellant in the said property have been affected adversely. It is exactly the same submission, thereby conferring a right on the appellant to prefer the instant appeal. Paragraph 8.
Have you gone through the judgment before citing it?
Yes. 2025 SEC.
In musical,
Calcutta.
the score sheets, there's a.
I don't know.
It goes down, allegro, and all those things. So it is gradually.
1017.
10178.
Upon a careful scrutiny of the impugned order, we find that the same, although couched as an injunction order, is in the nature of an order of attachment before judgment, so and so. Be it as it may, since the present appellant is neither a party, nor was any order of restraint passed on the present appellant, the order impugned in the appeal does not bind the appellant in any manner. This is exactly what my submission is. Moreover, in view of the frame of the suit in its present form, which is a money suit simpliciter, against we are also in a money suit. Ours is also a money suit, simpliciter. Against the defendant, respondent number 2, the appellant being a third party to the alleged loan transaction is neither a necessary nor a proper party to the suit itself.
What was the premise of the applicant there for seeking leave? What was the right they claimed to be infringed?
There was an injunction on a property, and they said that they had a right over that property.
In what sense? Right?
Immovable property, they had a right over the immovable property. I'll just read that portion also. The suit from which the present appeal arises is a money suit.
You require a copy of the judgment, sir.
Yes, Your Lordship. I think.
Can get
yes.
a hard copy? It's
I
easier.
think
Because you need to go through the facts also.
Yes, Your Lordship. Should we come back tomorrow? Because I don't have the copy right now. I'm very.
What other judgments you will be citing? You just.
I'll give a copy to him if required.
Yeah, telling the references also. The Mr. Bachot can come prepared on that.
I'm
We'll
extremely sorry
take
for
a
inconvenience.
plea.
I'm extremely sorry. But
No difficulty.
But I will have the copies tomorrow.
During arguments on the application for leave to prefer the appeal, it is submitted on behalf of the respondent number 1 that learned counsel requires some time to get relevant papers. So accordingly, let the matter stand adjourned for the day. Adjourned for the day. Adjourned for the day, it will remain in the list tomorrow. Under the same heading.
Much obliged.
Affidavit in opposition you have filed today? No.
No.
Right. Yes.
প্রপার্টি অ্যাটাচ হতে পারে সেক্ষেত্রে কোন ইন্টারেস্ট থাকতে হবে তার আগে প্রপার্টি লোনের কোনো সঙ্গে একটা ডিফারেন্ট একটা দেখলেই দেখে
in a suit for declaration and permanent injunction.
Yes.
There is an order of status quo so far the position and other things concerned. I'm on behalf of the defendant.
Status quo has been granted.
Status quo order was being granted. So, if your lordship kindly see page 125, it is an initial order. 125. Next page. After challenging the deed of sale and that and I the subsequent purchaser, I file an application for effecting the repair.
Mr. Chandra, what was the argument in the plain pleading?
Yes, my lord. If your lord
just basically, I mean, what was the facts pleaded by the plaintiff?
Yes, my lord, shoot for declaration and or for that and the sale deed was not binding upon the plaintiff.
Sale deed executed by the plaintiff?
No, he was not a party to that suit.
Achha.
He was not party to that
Sale
suit.
deed executed by your vendor.
In the initial 1950, there is a deed of partition between the several brothers and it was allotted, but there is a condition preemption right in preferential sale. Therefore, subsequent, if your lordship kindly see, lot A, B, C was there. In the 1950, partition was subsequently the person in whose favor the lot B was executed, rather allotted. There again, and partition deed was there. Then thereafter, the sum of the years, my predecessor in interest purchased the property. Thereafter, I am the subsequent purchaser.
So the plaintiff is one of the original co-owners.
No. He is a descendant of the original co-owner.
So he's saying that he's seeking to exercise that.
Allotted another.
No, he's saying that without giving any preference right to him, it was transferred.
But
that is his case.
Yes, but the portion of the predecessor in interest of the plaintiff, that is the separate lot. Not this lot.
Of the lots, the partition deed, the initial one of the conditions of partition was that there has to be a preference given if you sell your demarcated portion also.
Yes, my lord.
That is their grievance that you have not given.
It is their grievance.
Not you, but your vendor has not given.
Thereafter, my lord, that in the suit was filed in the year 1921. But the last date of
1921.
Sorry, 2021. Sorry. I may be corrected. Thereafter, my lord, the last deed of sale was executed in the year 2019. And my client purchased subsequent, but that is suit was executed, rather filed after the last execution of the deed of sale. Thereafter, my client purchased without knowing that order of status quo.
You are a lease pendants purchaser.
Yes, my lord, undoubtedly. But my humble submission before your lordship, kindly see my injunction application.
You have been implicated as a party here.
Subsequent by devolution of interest. But your lordship kindly appreciate that I file an application.
Yes.
That so far the portion I have purchased, that is partition portion. That is permission number separate one.
No, you have challenged the injunction order dated what?
Dated, my lord. Kindly
the initial ad interim injunction.
Yes, my lord. My lord, yes, I am also kindly come to plain memorandum of appeal.
Which order are you challenging?
50, order number 50. Order number 50. Dated 16 September 2025. Next page, my lord. Peruse, have your lordship got it? Next page. Yes. Peruse the case record. On perusal of the same, I find that the injunction petition filed Order 39 Rule 1 and 2 and Section such and such by the plaintiff has not been disposed of because they are taking time one after another.
But you purchased during the subsistence of the status quo.
Yes. Subsequent of the status quo. And my objection, our prayer is only, my lord, kindly allow me to repair the habitable condition of the premises.
No,
But
no. What has been done now? That injunction, that status quo has been made absolute.
that is pending, going on.
So what are you challenging? So what has been done by this order?
You kindly come to next. During the pendency of the application under Order 39(1)(2), that is the plaintiff application. We have to another application filed under Order 39(1) and 2 read with section such and such by the defendant number 10 and 11. This is my client. This is my client. Cannot be considered, and the same shall be considered after disposal of their application.
What injunction did you ask for?
Will kindly come to our application for injunction. Kindly come to my page.
You are permitted to repair.
Yes, condition, nothing. Trial court say, your lordship kindly see, trial court say only you can make rather repair only the
existing main door
main entrance
and plastering.
Plastering. Now your lordship kindly see our injunction application. Very innocuous PR. Kindly come to page 88. Have you also got it? Your Honor, may please to pass an order injunction restricting the plaintiff and the main agent with necessary machinery and repairing of the suit property as given in the schedule of the repairing and machinery work by the petitioner in NO. Now, your lordship kindly see the next 89. I purchased the property. I am the owner.
No, but there was a subsisting status quo order. You have already violated, your vendor has already violated that by transferring to you.
Undoubtedly, my lord.
You cannot be given a premium by doing untrammeled, unfettered
Actually, they purchase without knowing that thing.
Maybe.
I appreciate your
Bona fide purchaser for value without notice concept does not apply in section 52.
Only
if it was a specific performance suit, you could have understood.
My lord, only this is a trialable issue. My lord, kindly allow me only.
No, we appreciate that your sale may be irregular, not illegal.
Yes,
those arguments are there. We are not going into the merits of that. But this will be in violation of the status quo order. How can we be permitted to repair the
status quo as regard position? I am not interfering with the I am in position.
Status quo was not only with regard to position. Was it with regard to position only?
Yes.
Status quo is still in force. Where is the original order?
The original order is
the first annexure?
Page. Just now, 125, just now I am showing you, referring your lordship. 124, 125, order in portion.
Position, right, title, interest.
Yes.
Not nature, character.
Not nature and character.
So this is not contradictory to that.
Yes.
You have been permitted limited repair.
It says limited only for a habitable condition.
So what else do you want to do?
Not.
What else do you want to do?
Not. I am living there by.
What else do you want to repair?
Kindly see 89, page 89. In page 89. Schedule of repairing and machinery work.
Plastering of walls, patch repairing in the flooring, repairing of that is main entrance door to the premises.
Yes. Trial code allow me for main entrance of the premises, but does not allow the internal repairing. How it is possible?
Acha. No, allowed. Oh, only plastering at the main door. Acha. So you have not been granted plastering of walls, patch repairing in the flooring of your purchased property.
So that premises.
But without hearing the other side, Mr. Chandra, we could have disposed of. You serve everything on them. There is no scope of interim order on this. Because if you grant interim order and permit you to repair everything, the appeal is allowed.
But we are not that.
Will direct you to serve copy of memo as well as the application on the respondent, and pray to God that they appear and contest on the next day. Only on the plaintiff respondent number 1. Rest we are dispensing.
All have gone.
The present appeal has been preferred against an order whereby the subsequent purchasers stroke added defendants in a declaratory suit whereby the injunction application filed by the Jabollam in a suit has been postponed till hearing of a prior injunction application filed by the plaintiff, thereby amounting to deemed refusal of the prayer for injunction made by the appellants. Full stop. In the said injunction application, a restraint order was sought on the plaintiff from disturbing with the repair work intended to be carried out in the purchased portion of the present appellants within bracket added defendants bracket closed, while permitting a limited repair of the existing main door of the suit building, the other repairs pertaining to plastering of walls and patch repairing on the flooring of the purchased portion of the appellants was deemed to be refused. Full stop, we find a prima facie case having been made out. Full stop, accordingly, the appeal is admitted and shall be heard on the grounds mentioned in the memorandum of appeal. Full stop, since there is little scope of passing interim order, as any interim order, if passed, would tantamount to deciding the injunction application pending before the trial court itself, we direct the appellants to serve copies of the memorandum of the present appeal as well as Can 1 of 2026 on the plaintiff stroke respondent number 1, indicating that the matter shall be listed under the same heading in the monthly list of May 2026, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Next para. Along with the said copies, a server copy of this order shall also be served by the appellants on the plaintiff stroke respondent number 1. Full stop. We deem such notice shall be deemed to be a notice of the appeal itself, as we intend to take up the appeal for hearing along with the application on the returnable date. Acha, appear under the same heading, under the heading application. Under the heading application. We are putting it under the heading application so that it can be reached. But we intend to hear the appeal along with the application. Along with these copies, you serve a server copy of this order, since we are treating this to be a notice of the appeal also.
I'm appearing for the respondent number 1 led by Mr. Kushal Chatterjee.
Your Lordship, I'm praying for a short passover.
No. Then it goes out. You have to start the matter. What is the defect? Adjournment is sought on behalf of the appellants. Let the matter go out of the list. Leave is granted to the learned advocate on record to carry out the necessary correction to the memorandum of appeal in pursuance of the report given by the stamp reporter. Out of business. Next.
Lordship, in this matter, I appear on behalf of the appellant defendant in the suit, my lord. I'm being led by Mr. Jishnu Shah. Today, he's in some personal difficulty to attend before Mr. Jishnu Shah, my lord.
No, who is the advocate on record? So many people are there. Why are you naming Mr. Shah?
Lordship, advocate on record, I am the junior.
You are the junior.
Lordship.
So you had to effect necessary corrections.
Lordship, defects are clear.
Those have been cured.
I'm humbly playing, my lord, if it may be kept tomorrow, because, my lord, 20th April, the plaintiffs are proceeding with the execution before the London trial.
No, unless you start the matter, we are putting it out of the list. That is universal for all. You have to start the matter. If you start the matter, no difficulty. If you can't start the matter, it goes out of the list.
Lordship, I don't have instructions.
An adjournment is sought on behalf of the appellants. Let the matter go out of the list. Next.
Lordship, I beg to appear for
Yes.
the appellant. The defendant tenant
Yes.
in eviction suit is the appellant before your lordship. Lordship, there is I have served a caveat.
Lost in
And-
both courts?
No.
One court.
Before the trial court, lordship, the suit was dismissed. Before the appellate court, eviction decree has been passed.
On what ground?
Ground is reasonable requirement. On the ground is that the original plaintiff has two daughters and one son. And he claims that he requires so total 7 rooms. And he has explained that he requires 1 room for his business purpose, which his wife is carrying on. And she requires rooms for 2 of his unmarried daughters for study room and for them to reside. And my lord, 1 for herself. And 2 rooms for 2 servants.
For himself means the bedroom.
My lord, himself, yes, because at that time.
The bedroom.
Bedroom.
And what about the son?
And 1 for son.
1 for son and 2 for servants.
2 for servants. But the learned trial court was of the
There
opinion.
are total 7 rooms available now. How many rooms are available to him now?
My lord, as per the commissioner's report, 7 rooms are available.
In the suit property?
No, to the plaintiff.
Achha. And
Plaintiff is in possession.
And what is the extent of this suit premises?
Suit premises is in the ground floor.
How many rooms?
Ground floor, I am occupying 3 rooms. 3 rooms, 1 kitchen, 1 sanitary privy. The first floor is entirely, as per the claim of the plaintiff, it is tenanted. And the second floor entirely is occupied by the landlord, plaintiff.
You have 3 rooms on the ground floor.
Ground floor, and in ground floors, 1 room is in occupation of the landlord. Lordship, the learned trial court was of the opinion that the plaintiff has failed to prove his case on the score that no, the daughters didn't come to depose, that they required the property for the rooms. And also no servant came to depose, and also it is the admitted case that the business has not been continued since 1991. So he has failed to prove his case. This is on the basis of which the trial court may not pass the decree. The appellate court may not reversed it on the ground that the plaintiff is the best judge of his own case. And secondly, is that there is an admission that the daughters of the plaintiff come to the residence of the plaintiff. But my case is that the plaintiff in the plain says that there are 2 unmarried daughters and requires study room for them. My case is that the plaintiff's daughters are married and accordingly do not reside in the suit property. Thereafter, my lord, as far the business is concerned, it is admitted case the business is discontinued. And as far the servants are concerned, no one came before the honorable court to depose that yes, there is a servant or something has to be done for them. And my lord, the admission thing that is being said, that I have admitted that the daughters come to the residence of the plaintiff and they reside, there is no averment in the plaint, and it is not the case of the plaintiff that he requires the suit property for his married daughters who come to the suit property to the premises of the landlord, and requires it for the offsprings and family members of the daughters. But you kindly, may I take your lordship to the trial court's judgment first? Kindly takes up. Page number 92 of the application.
You can refer to the internal page.
Sure. Internal page. Page number 13. Lordship, the case of the plaintiff has been similar, stated that the plaintiff has contended that the plaintiff requires one room for her business, one study room for her two daughters, one room for her full-time maid and servant, and one room for the plaintiff. Further, it has been stated that the plaintiff also does not have any drawing room or separate rooms for her grown-up daughters. As such, presently, the plaintiff requires at least rooms apart from her present accommodation in support of the contention. Commissioner's report, plaintiff, and the same has been marked to exhibit. Lordship, the case of the defendant, Lordship, is that the plaintiffs are that the daughters of the plaintiffs are married and no scrap of paper or any document has been filed by the plaintiff to show that her married daughters reside at the suit premises. And moreover, no document has been filed regarding the presence of any maidservant. It has been contended the business of the plaintiff pertaining to spectacle has been
What
closed.
document regarding presence of maidservant?
Nobody has
Salary
come.
slip.
Nobody has come to depose. No servant has come to depose. Maybe no document, but nobody has proved the case. Lordship, kindly takes up, Lordship, the findings of the learned court below. Upon scrutiny of the commissioner's report, which has been marked in as exhibit, it can be seen that the suit building is a three-storied building of Paka construction. It has been stated by the learned advocate commissioner in point number 1 of the said report that 7 rooms were found to be in occupation of the original plaintiff. And all those rooms were situated on the second floor of the suit building. Out of the said 7 rooms, 3 rooms are found to be spacious, measuring more than 100 square feet, which is ideal for habitation. The plaintiff has stated in the plain that she requires 7 rooms for her reasonable requirement, as stated above, but at that same time, no satisfactory document has been filed by the plaintiff to show that she has a full-time maid servant and another servant. Moreover, no proper explanation.
The husband died.
Husband died.
Achha.
Now the wife. Moreover, no proper explanation has been given by the plaintiff to show the presence of her maidservant, namely Panchi Sarkar or Pintu Maiti, or any sufficient cause has been shown by her which precluded her maidservant to depose before the court. At the same time, it has been stated by the plaintiff that she has a business, but no document or any scrap of paper has been filed by the plaintiff.
Maidservant was called to adduce evidence, she would leave job.
As regard the requirement of her married daughters and sons, none of the daughters or sons of the plaintiff came to depose before this court to show that they reasonably required the suit property for their own use and occupation. Upon scrutiny of the documentary evidence as well as oral evidence, it appears that the plaintiff has got ample rooms in her occupation in the suit premises number such and such, comprising of 7 rooms in occupation of the plaintiff, which is sufficient for plaintiff, her sons and daughters. As such, it is clear that the present accommodation of plaintiff is more than sufficient compared to the prayer of reasonable requirement in the suit premises.
T are habitable. And second floor premises cannot serve the purpose of business, which you say is.
He has not been able to prove it. Now, Lordship, what the learned apple court Lordship has said is that I'm only on the ground that it has been stated that the plaintiff is not required to prove the case. Because I have admitted the claim. Lordship kindly takes up internal page 6.
That is only regarding married daughters.
The entire case. Because it has been stated that the case has been admitted, accordingly the plaintiff is not required to prove it.
What did you admit actually?
Admit that there are married daughters who sometimes come to the property of the mother.
Rooms for married daughters is now settled.
But this is not the case of the plaintiff. He has not sought for it.
He has sought 2 rooms for his daughters.
Two single room for daughters. Single room for 2 daughters.
If the 2 come together, then what happens?
Lordship,
they are equally heirs of the property.
Lordship kindly takes up the plaint
after the demise of the father. They are also owners of the property. Don't forget that marriage does not mean their ownership goes. Their right to come back to their matrimonial home, the parental home goes.
I am not on that.
And they're co-owners of the property. Don't forget that. We always say married daughters, but they're co-owners of the property also.
I am not on that. I am only saying that this is not the
How
plain
does marriage
case.
change the position? Because they wanted. Now please come to that portion where you are reading.
Kindly takes up
page 13. You are reading. Page 13. Their case is that grown-up daughters, separate rooms for them.
May I?
Not study room.
May I read?
Page 13 you read. It has been stated that plaintiff also does not have any drawing room or separate rooms for her grown-up daughters.
Yes.
So grown-up daughters are not married.
Yes.
So if they come together, then they won't require two rooms, two grown-up daughters.
Actually, this was not at all the case. The case was that
That's
there are.
Evidence you said that you admitted that the married daughters come to the.
This
that
was
one.
never the case that they have been married and they required the property for
Marriage is
married
not required
daughters.
to be pleaded.
Nothing
He
was
required
there.
2 rooms for 2 daughters. Grown-up daughters, he requires 2 rooms. Married or unmarried does not make a difference.
Actually, may I read the plaint for once in that?
Married or unmarried does not make a difference. Why should he stay?
One room for study of his 2 daughters. One study room, not one room, no, not one bedroom, and a room for occupation of full-time maidservant. And thereafter, my lord,
The daughters won't live in a room.
at present, a bedroom of it is used by the plaintiff and 2 married daughters.
Till later passing of the degree, final degree court can consider as judge. Yes, Mrs. Chatterjee, not a substantial question of law.
Actually, one room for her full-time maidservant. The plaintiff has contended that the plaintiff requires one room for her business, which is not being continued. One study room for her 2 daughters. One study room, not one bedroom. One room for her full-time maid, which has not been proven, and servant, and one bedroom for the plaintiff.
Existence of the daughters is admitted.
Admitted. Further, it has been stated that the plaintiff also does not have any drawing room or separate room for the grown-up daughters. As such, presently at least 7 rooms apart from her present accommodation is required. See, my case is that it was never pleaded that they require for married daughters and all. It was denied. It was stated that he stay with the plaintiff. And there is no question of admission, because as far as the other grounds are concerned, that servants and business, this was not proven. Only ground on which, my lord, the suit has been decreed is that with that page number 7 of the appeal court's judgment, lordship.
One room for her full-time maid and servant. Each maid. Page 6. Maid the full-time servant has. Room.
The Shubhankar Ghosh in his testimony has stated that the family of the plaintiff comprises of herself, her son, daughter-in-law, and one grandson in one house. And Dibakar Ghosh has admitted that sisters of Dipankar Ghosh are married. Dipankar Ghosh is my brother. Internal page number 7 of the appeals court's judgment.
Appeal court 7. Dipankar Ghosh is the plaintiff. Not the
Dipankar Ghosh, Gude is the plaintiff. And the daughters and sons, my lord, they were not made parties.
Made parties?
They are not parties.
Why should he be made parties?
They are not the, my lord, they are not made parties, and they didn't come to depose as well. Actually, kindly, my lord, one more point, lord. So kindly text, my lord, the commissioner's report says that there are unused rooms, my lord, my lord, rooms.
3 large rooms which are habitable.
My lord, kindly text up the commissioner's report for once.
What is that?
Actually, it begins from 24, page number 24.
Yes.
So kindly takes up internal page number, page number 33 of the stay application. Room number 7.
Yes.
If it is 9 feet north to west and 11 feet east to west. Room situated on the western side of the roof, and it measures as follows. It contains one wooden table, one grinding machine, one wooden bench, refused articles, However, I found that the room is lying abandoned condition, full of dust. This room has necessary electrical fittings and fixtures, and this room is made of asbestos roofing, cemented floor, such and such.
The present second appeal has been preferred against the judgment of the first appellate court, whereby the learned first appellate judge reversed the decision of the trial court, dismissing the plaintiff stroke respondent's eviction suit, primarily on the ground of reasonable requirement. So next para, learned counsel appearing for the appellant argues that the case as made out in the plaint contemplated requirement of 2 rooms for the study of the daughters of the original plaintiff, comma, since deceased. Full stop, next para. However, comma, the learned appellate judge came to the finding that the daughters of the plaintiff, comma, whose wife is now the plaintiff, comma, have since been married, comma, which is a deviation from the original plaint case made out. So it is submitted that the factum of marriage of the daughters has not been disclosed in the plaint by way of amendment or otherwise. Full stop. In the absence of any proof that the said daughters, that each of the said daughters require a room, comma, the learned appellate judge erred in law in granting the prayer of reasonable requirement for such daughters. Full stop. Next part, it is further submitted that 1 room was allotted as per the plaint case for the purported business of the present plaintiff, that is the wife of the original plaintiff, comma, which business has long been discontinued. Full stop. Next para. Thus, comma, the purported requirement of the plaintiff on such ground was also erroneously allowed by the appellate judge. Full stop. It is next contended that the learned appellate judge failed to look into the commissioner's report, from which it is evident that room number 7, comma, which is one of the 7 rooms available to the plaintiff, comma, is lying unused, comma, with refuse articles and accumulation of dust therein. Full stop. The proportion of the said room, comma, it is submitted is 9 feet by 11 feet. Full stop. The fact that the said room is not being used despite being available goes on to show that the plaint case of requirement was fictitious. Full stop. Next para. Upon a perusal of the judgments of both the courts below, comma, we find that the plaint case pleaded 7 rooms to be required by the original plaintiff. Full stop. 1 was apparently for the habitation of the plaintiff, comma, in whose absence, comma, for his wife, comma, the present plaintiff stroke respondent. Full stop. 2 rooms were pleaded to be required for the grown-up daughters, for the daughters of the plaintiff, comma, designated for their study. Full stop. That apart, comma, 1 room was required purportedly for the business of the present plaintiff and 1 for the son of the plaintiff. Full stop. There was another room required for the servants of the plaintiff. Full stop. Next para. Insofar as the commissioner's report is concerned, comma, the same was discussed by both the courts, and it transpired that even in the opinion of the trial court, comma, from the commissioner's report, it was reflected that all the 7 rooms in occupation of the plaintiff were situated on the 2nd floor of the suit building. Full stop. Next para. Out of those, comma, 3 were found to be spacious, measuring more than 100 square feet, which was held by the learned trial judge to be ideal for habitation. Full stop. Next para. Thus, fact remains that the plaintiff, if the plaint case of requirement is to be believed, required at least the 3 rooms which comprise of the suit premises. Full stop. Next para. Insofar as the arguments of the appellants regarding the married daughters having no requirement for 2 separate rooms, we are unable to accept the same. Full stop. The quality of requirement for 2 grown-up daughters does not alter with the factum of their marriage simpliciter. Full stop. Even married daughters are equally entitled to a room of their own when they come to visit their paternal house. Full stop. Next para. Even otherwise, married daughters also have a right as co-owners of the parental property. Full stop. Next para. If 2 daughters come simultaneously, they would in any event require the 2 rooms. Full stop. Next para. With regard to the business of the wife, the mere fact that there was a previous business which was discontinued cannot deter the said businesswoman from requiring a room for her business, since it may very well be that due to want of a room for such purpose on the ground floor, the business cannot be run. Full stop. Next para. It is well settled that in order to establish personal requirement in an eviction suit on the ground of business, no proof of running business in presenti is required to be furnished by the landlord. Full stop. Next para. Insofar as non-examination of the servants or any documentary proof of the existence of servants is concerned, it is within common knowledge that a family unit may very well require domestic help for the purpose of catering to its daily needs, for which no separate proof was required to be furnished. Full stop. Next para. Thus, we do not find any substantial error of law having been committed by the appellate court in decreeing the eviction suit by reversing the judgment of the trial court. Full stop. Next para. That apart, the learned appellate judge, first appellate judge, rightly proceeded on the well settled premise that the court has to sit in the armchair of the landlord to decide as to what is his / her requirement, and the requirement of the landlord cannot be determined by the tenant. Full stop. Next para. In any event, the location of the present accommodation of the appellants of the landlords at the 2nd floor of the premises also rules out user of any of the said rooms for the purpose of the wife's business in any event. Full stop. In view of the above, we find that the questions sought to be raised by the appellants, even if those were to be accepted, range within the domain of pure questions of fact, and there is no element of substantial question of law involved in the present second appeal. Full stop. Thus, SAT 46 of 2026 is dismissed under order for 11 of the Code of Civil Procedure. Consequentially, can 1 of 2026 stands dismissed as well. No rest to cause urgency. Sorry, yes, sir. Next. Yes.
I started my submissions on the last day, and after that, not the matter has been hanging. Lord, this is that disparagement action, Lord. Volini, your lordship will remember. Sticky, smelly.
6 minutes. 6 minutes.
Not
Only one purpose will be served.
Not one, multiple purposes, but But yes, your
Very well,
lordship is
yes.
right. I mean, not much can be done here in this time.
So, due to paucity of time, comma, the hearing cannot be concluded today, full stop. Let the matter be posted for hearing next tomorrow.
I'll second half. Yeah, what's the problem?
I said I have no problem.
Yes, sir. How do it?
They over here,
Not my
everything. Be
appeal.
careful about what you say.
It's my appeal.
But one is heard of
In the second half, will it retain its own position?
Yes, in the under the order 41 heading, it will. One matter has been fixed, but that was above your matter. No.
But one has heard of the long arm of the law, but one sees that not long
No,
ear.
no,
also.
you are speaking near the microphone. That's it.
My lord, I am appealing for the appellant. My lord, my suit, my lord, stood dismissed. Now, my lord, what happened, my lord, here? Suit for declaration that the sale deed executed by the defendant number 3 and 4 in favor of defendant number 1 and 2 is bad in law. Now, my lord, the trial court, my lord, has dismissed the suit, my lord, on the ground that my suit, my lord, which I have filed it, my lord, I have other remedies. I can avail that. Yes.
What
My lord, what happens is, my lord, the court says that I can approach the court, my lord, in preemption under the Partition Act.
You are
My
a
lord, I can
co-owner.
preempt. Yes, my lord, I am a co-owner. My lord, I say, my lord,
Yes, but
yes, but that doesn't bar my suit. This suit, because my suit will be governed under
that is the
section.
only ground of the trial
My
court.
lord, if my lord sees
You
the
must be
trial,
misleading us. Mr.
No, no,
Cannot be the only.
my lord, kindly see.
The appellate could affirm that on what ground?
Appellate court also went into section 44, which says a co-owner can transfer his share. So there is no bar. I can at best have an.
On what ground did you file the suit? I mean,
My
why
lord,
is
my ground, my lord, is that I am one of the first class heirs, among the first class heirs. I am one of the heir and defendant number 3 and 4, the other heirs. So therefore, suppressing everything without having the knowledge, they sold the undivided share in favor of defendant number 1 and 2.
But there is a bar in that per
My
se.
lord, section 22 of Hindu succession and conflict.
Yes.
My lord, it says, after, my lord, if in that case I have a preferential right.
Right?
My
That
lord,
is precisely what the appellate court has said.
yes, now, my lord, our honorable High Court has held, my lord, this is a case after post transfer,
Post sale.
then a suit will lie. So, my lord, my suit will lie, declaration that sale deed is bad on that ground.
Suit will lie for preferential exercising of preferential right
My
of
lord,
purchase.
possibly, my lord, 2008 says on a different line.
How can the sale be vitiated?
Yeah.
One co-owner can sell his shares to some other person.
No, my lord, I have a right to challenge that sale deed, saying that you have not complied with section 22.
There must have been a clause in some partition deed there or something.
No, there is no undivided. It has to be undivided.
Section 20 একবার হিন্দু সাকসেশন একটা দিন তো সাকসেশন অ্যাক্ট হিন্দু সাকসেশন হিন্দু ল বলে জেনারেল কোনো থাকলে তার মধ্যে থাকবে আগে যেন হিন্দু ল থাকতো না সাকসেশন
তুমি Maharaj got section 22, my lord.
Yes. We are getting section 20.
My lord, may I just place it?
You are also in this matter?
No.
Where after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon 2 or more heirs specified in class 1 of schedule, and any one of such heir proposes to transfer his or her interest in the property or business, the other heir shall have a preferential right to acquire the interest proposed to be transferred. The consideration for which any interest in the property of the deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all cost of or incident to the application.
So you have to make an application for that.
No, my lord, this is where, my lord, pre-sale. My lord, what happens after post-sale? My lord, here, my lord, a sale has taken place. My lord, then, my lord, I come to court by filing a suit seeking declaration that sale is bad because you have not offered me that right to purchase.
We'll continue with this tomorrow.
Very well. সেল করে দিয়েছে Yes, that is true. We both were arguing.
What have we done? Dismiss the appeal for
Out of list.
only out of list. Out of list. No. Consistent. You keep this with you, Mr. Chatterjee. Give it again. Act out. All the matter is barely commenced, the same cannot be concluded due to paucity of time. Accordingly, let the matter retain its position in the list tomorrow. No.